was it. So appreciate that. So I just want to start off with roll call. I think that's what we have on our agenda here this morning. So can we start off with a roll call with that Pam?
Yes, and I just let Member Duval into the meeting.
Great.
So he is here, and I will begin roll call with Member Bitzer. Are you present?
Here.
Okay. Member Cates.
Here.
Thank you. And Member Duval.
Here.
Thank you. Member Garcia.
Here.
Member Trujillo Davis. You're muted, but I see you. Okay, there you go. Member Honker.
Present.
Chair Sweeney.
Also present. Thank you so much. Thank you. And just to start off, I just wanted to again reiterate, Member Duval, I wasn't sure if you heard, but we had a little bit of potential technical difficulties. But with that said, I think we just double checking with our legal counsel and Pam that we got all the public notifications all resolved, all check marked, that we are good to go this morning. Is that correct?
That's correct.
Okay. Thank you so much. And I just want to have that noted because of our slight potential technical difficulties for this meeting this month. So that said, I wanted to, let's go to the next item, which is approval of our agenda today. For our members, if you've reviewed our agenda, and if you have, I'd love to entertain a motion, and then if we have any discussion after.
I move to approve the agenda.
Thank you, Mr. Honker, for your,
Second.
and Member Garcia seconds. And any discussion on this agenda item? If not, I don't see any. Can we have a roll call vote just so that we are clear for our court reporter and everybody?
Yes. To approve the agenda, Member Bitzer, how do you vote?
Yes.
Member Cates?
Yes.
Member Duval?
Yes.
Thank you. Member Garcia?
Yes.
Member Trujillo Davis?
Yes.
Member Honker?
Yes.
Chair Sweeney?
Yes.
Madam Chair, the motion passes unanimously.
Thank you so much, Ms. Jones. I appreciate that. So with that vote, let's go on to the next item, item number 3, which would be the approval of our March 26, 2021 meeting. And I understand that there was a little 2 drafts, is that correct, Ms. Jones, that came out?
Yes, the March 26th minutes were sent in a separate email.
Okay, great. And I just want to double check with all our members that you got the revised version, and that's what we'll be considering during this agenda item. Great. So with that said, if we've all reviewed the revised version, may I entertain a motion so that then we can discuss?
I'll move to approve the minutes.
Thank you, Member Bitzer.
I'll second.
That was, I believe, Member Honker, that second.
Yes.
Thank you. If there's any discussion on this, if not, I don't see anybody raising their hand. I'm trying to pull, I have a quick question, technical question. Do you know how to pull the screenshots of others in the other frames over? I want to make sure I have Vice Chair Amanda Trujillo Davis on my front screen and also Member Duval. Do you guys know how to do that?
Chair Sweeney, if you find the person's screen and click on the upper right corner of their screen, you
Okay.
should be able to add a pin.
Okay,
And so the pins are limited, but if you want to add the members, pin them, and that way they're always at the forefront.
okay. Oh, I see, I see. Gotcha, gotcha. Okay, thank you so much for that. Appreciate it. Sorry for that technical question there. I just wanted to make sure I have all our members on the screen so I can see if any of them have any motions or want to get my attention. So thank you. With that said, Ms. Jones, could we have a roll call vote on the passage of our meeting minutes?
Yes, to approve the minutes from the last meeting. Member Bitzer, how do you vote?
Yes, aye.
Member Cates,
Yes.
Member Duval,
Yes.
thank you. Member Garcia,
Yes.
Member Trujillo Davis,
Yes.
thank you. Member Honker,
Yes.
Chair Sweeney.
Yes.
Very good. The motion passes unanimously, Madam Chair.
Thank you so much, Ms. Jones. Appreciate that. All right, so we're on to our next item, item number 4, which is EIB 21-27 in the matter of proposed new regulation 20.2.50 NMAC oil and gas sector ozone precursor pollutants. Request for hearing and appointment of hearing officer. Our presenter will be Laura Cates, counsel for the New Mexico Environmental Department. Ms. Cates, are you present? Yes, I see you. Great, thank you. Great to see you today.
Good morning, Madam Chair.
Good morning, and welcome. And at this time, I will turn the floor over to you. Thank you so much for being here.
Thank you. Good morning, Madam Chair. Good morning, members of the board. My name is Laura Katz. I am counsel for the New Mexico Environment Department. The department is here before you today on the department's petition for regulatory change, requesting that the board set a hearing to consider a proposed new air quality regulation at 20.2.50 of the New Mexico Administrative Code. This regulation would target emissions of ozone precursor pollutants from the oil and natural gas sector. And it will also have a co-benefit of reducing methane emissions from that sector. As discussed in the statement of basis accompanying the petition, the Air Quality Control Act requires the board to prevent and abate air pollution. And it specifically requires that the board adopt a plan including regulations to control emissions of ozone precursor pollutants in areas of the state that are experiencing rising ozone levels. As part of this rulemaking, the department will present testimony regarding its ozone attainment initiative, which has been underway since 2018. And it will ask the board to adopt the elements of that initiative as the plan that's required under the statute. The proposed regulation at Part 20.2.50 NMAC is the first formal rulemaking under the plan. Future rulemakings will target other sectors that contribute to ozone concentrations in the state, such as transportation. The petition outlines the extensive public and stakeholder outreach that the department conducted prior to formally petitioning the board. That process spanned 2 years and included the release of a pre-petition draft rule for public comment and input. The department also worked closely with the New Mexico Energy, Minerals, and Natural Resources Department in developing the proposed regulations, such that they will work in tandem with MNERD's recently promulgated regulations targeting natural gas waste from the oil and gas sector. Sorry about that. Excuse me. So the petition, in the petition, the department is requesting that the board schedule a hearing on the proposed regulations to begin September 20th. We are also requesting that the board adopt a schedule for pre-filed, written, direct, and rebuttal technical testimony. The pre-filed direct technical testimony, we would request the due date for that would be July 28th, 2021. And the rebuttal testimony due date would be September 6th. By requiring this schedule and the pre-filing of technical testimony, it helps promote efficiency at the hearing, and it'll allow the parties to fully develop the issues, identify areas of agreement, and then really be able to crystallize the true controversies that the board needs to resolve. Finally, the department is requesting that the board appoint an experienced administrative hearing officer to conduct the rulemaking proceeding. We expect that the hearing will, just depending on how many, the interest and how many parties are involved, we are expecting the hearing to take approximately 2 weeks. So in sum, the department believes that this proposed regulation is a critical first step towards reducing ozone concentrations in this state for the benefit of public health and the environment. And we would request that the board set a hearing and the schedule as proposed in the petition. And I forgot to state at the beginning that I do have with me today here the Elizabeth Bisbee Keene, who's our Air Quality Bureau chief. And so if there's any questions that either I or she can answer, we're available and to stand for those.
Thank you so much, Ms. Katz. I appreciate the presentation and the information that you provided this morning, as well as the documents that your office and the New Mexico Environmental Department provided to our board. At this point of time, just point of order, I just want to make sure, legal counsel, do we allow for questions now? And then I know there's some requests for some additional input from other stakeholders. Is that the process?
Sure, Chair Sweeney, if the board has questions for the department at this time, I think it's appropriate to consider those. Again, as a point of order, I have a list of counsel who have entered their appearance, and I do think it would be appropriate for the board to not address the merits of the petition itself, but to the extent that those parties have input regarding the scheduling of the hearing and the appointment of hearing officer, the board can hear from them. And those counsel that I have are Elizabeth Paranjos, Tanis Fox, David Baque, I apologize if I'm butchering people's names, and Eric Heiser. So after the board has questions the department, then you can move on to those parties who I believe are all on the line.
Thank you so much, legal counsel. I appreciate that. And I just want to make sure that gets into the record. These other stakeholders that do want to have some time with the board, since we didn't have that on our agenda, but just so that we're making sure that we follow the correct order. So board members, just the floor is open to you. If you have any questions of our legal counsel, Ms. Cates here. Yes, Mr. Member Honker.
Yeah, just a point of clarification on the recommendation for hearing officer, I assume that means someone other than one of the board members, a third party, an external hearing officer who is very experienced at doing this sort of thing. Is that the recommendation?
Yes, Member Honker, that is the request of the department. We believe that this is likely to be a very complex hearing and both procedurally and legally. And we feel like it would be very important for an experienced hearing officer to conduct the proceeding, and that would then also allow all the members of the board to fully really be present to listen to the testimony and really get the substance of that. And so that's why we're requesting that, and the department our Office of Public Facilitation can work with the board to appoint somebody for that role.
Okay, thank you.
Thank you for that, Member Honker, and for your response, Ms. Katz. Do you have any other questions, Member Honker or other board members? Yes, Member Garcia.
Thank you, Madam Chair. Does the department have a hearing officer on contract that we could utilize?
Yes, Member Garcia, we do. We have contract hearing officers that can be utilized.
Right. Thank you.
Thank you, Member Garcia. Member Amanda Trujillo Davis.
Actually, Member Garcia asked the question I was going to ask, so thank you.
Thank you, Member Vice Chair Trujillo Davis. Yes, Member Cates.
Yeah, just wondering, over the course of this 2 weeks, this will probably be a pretty voluminous amount of testimony. So will we have the chance to review that testimony?
Recording in progress.
Before we deliberate? Judge? Hello?
Yes, Member Cates. The direct testimony would be filed at the end of July, and it would be available for the board to review that time. And then the rebuttal testimony would be filed September 6th. So that would be a couple weeks before the hearing. So the board would have the opportunity to review all that technical testimony prior to the hearing to be able to have that aspect to be prepared for hearing the testimony. And the way that the hearing would go would be that the parties that submitted that technical testimony would summarize it at the hearing, and then would stand for cross-examination and questioning from the board. So it would help. So yes, you would have access to all of that testimony at the time that it's filed prior to the hearing.
Right, right. And when do you think that, I mean, what would be the expectation for a ruling, a timeline for that? By the end of the year or something?
So the department would work with the hearing officer that's appointed and all the parties to come up with that schedule. But it would, yes, it would look something like there would be a post-hearing briefings following the hearing. If the board wanted it would probably be a good idea to have the hearing officer file a report, and then the board could deliberate based on that. So it probably would be going into next year, but hopefully early next year.
Okay, got it. Thank you. Thanks.
Thank you for your question, Member Cates, and for your response, Ms. Katz. Any other board members have any other questions? If not, legal counsel, at this point, just again, point of order, I just want to make sure we do everything appropriately. Do we just call the others one by one for their comments?
That's correct, Chair Sweeney, and I can, since I have the list, I can call them in really no particular order, but if you'd like me to do that, I can do that.
Yes, thank you. Thank you so much.
So I believe we have counsel from the Environmental Defense Fund, Ms. Peronjos.
Right. Yes, legal counsel from the Environmental Defense Fund. Are you on? Let's see. I don't see her name. And if you're on the phone, please let us know.
Ms. Jones, are participants able to unmute themselves? Just in case there's another person appearing for this party.
Yes.
Okay. Well, since we're not as of yet hearing from the Environmental Defense Fund, we can move on to Counsel for the Western Environmental Law Center. I believe that's Ms. Fox.
Thank you. Thank you, Ms. Fox, for being present. And yeah, so welcome and please have the floor.
Thank you very much, Madam Chair, members of the commission. My name is Tanis Fox. I'm with Western Environmental Law Center, representing here today a number of civic and environmental organizations. And we have no objection to the department's proposed schedule. And I guess would second the suggestion that the board appoint an experienced hearing officer for this particular hearing. Thank you.
Thank you so much, Ms. Fox. I appreciate your input there. And legal counsel, go ahead and go. Maybe I should ask, do we ask if, it seemed very straightforward, but if, as we go down, if any members have questions, should we ask for questions after they present?
Sure, that's
Okay.
that's appropriate.
Great. All right, legal counsel.
So another party who has entered an appearance is Mr. David Baque on behalf of the Council for Conservation Voters, New Mexico, Giant Care Earthworks, Natural Resource Defense Council, and the San Juan Citizens Alliance, Sierra Club, and 350 New Mexico.
Thank you. David, are you here?
Madam Chair, Mr. Bach and I are co-counsel, and so I'm here representing those organizations and have stated our position.
Thank you so much, Ms. Fox.
Okay, and finally, we have the New Mexico Oil and Gas Association, and I believe Mr. Eric Heiser is present for them.
Good morning, Mr. Heiser. Thank you so much for coming. And the floor is yours.
Thank you, Madam Chair, members of the board. My name is Eric Heiser with Jordan Heiser and Joy, and we are lead counsel for the New Mexico Oil and Gas Association, which is basically the regulated industry in this case. I know that your agenda time is brief, so I'll be brief. We really have just 3 points we'd like you to consider as you take up this petition. The first is that this petition is premature and lacks some of the elements that you're going to need to do your job. The statute says that the department or the petitioner needs to present a plan, including rules to control emissions for attainment and maintenance. And what we have here is many regulations, but we don't really have a plan. And without that plan, which has a defined meaning in this area, you don't have the tools that you need to have in terms of what are the goals, how do these measures advance those goals, and will they actually be able to achieve that goal? So we think that NMED hasn't quite brought everything to the table that you need in order to take this matter up. So we think it's premature. Our second concern is that more time is needed to give people the ability to respond to the petition, given what it is. This is a big petition. NMOGA had asked John Dunham and Associates, an economic firm, to estimate the impact of the rule, and it's about $4 billion. That's billion with a B. So this is a really big decision that you as members of the board are being asked to reach. And while there has been a lot of process, as Ms. Katz pointed out, it hasn't been about this rule that's in front of you. Our colleagues at EDF estimated that on their numbers, this rule probably sweeps in 45,000 or 40,000 more facilities than the pre-petition rule did. And that's a big change. This rule also mandates that we discontinue use of controls that are used extensively throughout the industry and particularly in the Northwest. And that's a change from the pre-petition of the rule. And NMED itself is still in the process of uploading much of their data to the websites to make them available to either the environmental petitioners or to the industry petitioners to fully understand what's being done. And lastly, there are gigabytes, if not terabytes, of modeling information that we need to try to get through. And we have less than 60 days before we have to have our technical testimony in. It's really not feasible for industry to do a good job in presenting its views of this in the time frame that's been given. And third, our third point would be, we agree with Ms. Katz and with Ms. Fox that this is really a case where a hearing officer should be appointed. And we'd ask you to charge that hearing officer with looking at that preliminary issue of, is there enough information here? And second, polling the parties to really come up with the best possible schedule for you to do your job right. You have a big task ahead of you, and we appreciate your consideration of our views. Thank you.
Thank you, Mr. Heiser, for your comments. And at this point, I'd like to turn to the members if you have any questions. Yes, Member Bitzer?
Yes, I would like to hear from the department about Mr. Heiser's contention that they don't really have a plan yet.
Thank you, Member Bitzer, for your question. I'll turn it over maybe to Member Katz.
Thank you, Madam Chair and Member Bitzer. Yes, the department obviously would like to respond to Mr. Heiser's statements. So regarding the plan, the department has been conducting its ozone attainment initiative since 2018. We've made that very public. That is, I know that Mr. Heiser's client is aware of it. As part of this proceeding, we will present the testimony about that plan, and the way that the statute is written, it does say adopt a plan. And so to be in line with that, the department will put forth that entire plan, and it's significant, and it's underway. It's already underway. So I would disagree that there needs to be any further development on that for the board to consider this first piece of it. And so there's a full opportunity to develop that through this process. As regarding the timeline, this is the timeline that the department has proposed is extremely generous by rulemaking standards. It goes far beyond the requirements of the rules or statutes. The department engaged in such a significant pre-petition outreach, including a draft rule, which is for comment. NMOGA has had, the rule was filed May 6th. We're proposing the hearing in September 20th. That's 4.5 months. That's the longest time frame of any rulemaking I've ever been involved in, any rulemaking in this board or any other commission involved with the department or other agencies that I know of in recent memory. The most recent analogous rule would be the greenhouse gas rules from 2010. That rule was proposed in, it was another complex rule, was proposed in, the petition was filed in early June for a hearing in September. There's more time here. They have the entire language of the rule that they've already been able to start. We've provided them with extensive modeling data that they've requested from us. And of course, we'll make that available to everyone else. There's some technical documents that still need to be uploaded, which will be uploaded by the end of next week. So that is, and there's the whole time between now and the hearing to develop the issues. So I will also say that the department has, you might be aware, many other things that it is working on, and we proposed a schedule that was as long and generous as possible to deal with all the other matters that we have to deal with, including things that we have to bring before the board. So it's very important to us for that schedule to stay on track, and it is a very generous schedule.
Thank you, Ms. Katz. Appreciate that response. Member Bitzer, I know you probably have a
I'm
follow-up.
sorry, I'm going to defer to Member Trujillo since she got her hand up, to Trujillo Davis.
Okay,
Sorry,
member,
I can see her hand.
thank you, Member Bitzer. Vice Chair Trujillo Davis?
Thank you. I just wanted to follow up on one of Mr. Heiser's points was, I just want to make sure I got it correct. Did you request that the hearing officer review the rule and the current data? Can you repeat that portion of your request?
Thank you, Madam Vice Chair. The request that we had was that this board, because there's really not enough time to delve into those details, to ask the hearing officer to look at the question of whether it's premature, and then to poll the parties to recommend the best schedule moving forward. We're looking for like a 30-day delay is what we're looking for. Thank you for your question.
Thank you, Mr. Heiser.
Thank you. And I'd like to pose my question to the other board members. Reviewing the information that was submitted, I mean, it is a very complex rule. To my other board members, do you think that there's any merit in having a hearing officer review all the technical documents that were submitted along with the current rule that we have in front of us? And is there precedence for this?
Thank you, Madam Vice Chair, for your question. I'll look to our members if you have any input on that. Member Bitzer? Oh, go ahead. Member Duval.
Yeah, Madam Chair, it sounds like there is precedent for this, and I can definitely see the the validity of the request. I guess I wasn't quite certain what Member Trujillo Davis was. I didn't. Can you repeat your question? I didn't really understand what you wanted to hear from us.
Yes, Madam Vice Chair, can you explain?
Yes. So just in reviewing the information that has been submitted so far and seeing in there that there are supporting technical documents, and there, I believe, if I understood Ms. Katz, that there are a couple more that are going to be uploaded by the end of the week. Should we have our hearing officer review this very substantial amount of information and make a recommendation back to the board?
Oh, I see. If there's going to be a hearing, I mean, my personal thought would be if there's going to be a hearing officer that's outside of the board, then they obviously need to be up to speed on all the other documentation as well. I don't know that would necessarily influence my reading of the documents on my own, because I think we all need to be doing our homework for that. But I think that absolutely it would be appropriate for them to review everything and make some kind of recommendation, I guess. Yeah, I support that.
Thank you, Member Duval. Member Garcia, did you have a response?
Yes, I can see, I mean, it makes sense that because this is obviously going to be a controversial hearing, that it would start from the get-go being controversial. Here we are. However, I think with an experienced hearing officer, I have no doubt they will be prepared in the time that we have for this hearing to start on September 20th. So I would expect that unless there's any scheduling changes that the two parties wish to work out, I would expect that we could go ahead and move forward with the hearing and work through all the issues at that time.
Thank you for your input, Member Garcia. Any other members have any response or input? Member Honker.
Yes, just I guess a question for Pam or Carla. September, I would guess there's a possibility we'd be face to face by then. I'm just wondering if there's any sense from you all whether we'll still be doing this remotely by September, or is there a possibility this whole hearing could be a face-to-face hearing situation? Just curious.
Member Honker, you know, as much as I would like to be a crystal ball, we have not heard anything about a date certain as to when in-person gatherings or hearings of this nature can take place. I would defer to Department's counsel if she has had any indication as to that. So I'll defer to her, but I do not have any advance intelligence on that.
Thank you for that, Carla, and Member Honker for your question. Ms. Katz, do you have any insight into that?
Yes, Madam Chair, Member Hunker. Because the department will need to publish notice of the hearing, it has to be published in the New Mexico Register 60 days before the hearing. So because of that, I believe it would have to be virtual because by that we won't know by then, I think, that we can be in person. So it will need to be virtual.
Okay, that makes sense. Thanks for that.
Thank you. Yes, Member Bitzer.
I wondered if this the department attorney had any further things to say. I was doing a little facial recognition expression concern, and it looked like you had something further to add. And I know you won't say it unless you're asked. So what else did you want to add?
Thank you, Member Bitzer. That was actually partially because my children are out of school and they're home, and so I did want to be able to add so that yes, so I do not think we'll be in person based on when we need to give the notice, and I think we'll still have to accommodate virtual hearings, and I think it'll at that time, or at least some aspect of virtual hearing, and that's something that we would continue to need to work with the board and the hearing officer toward. I'm also wondering if I might respond to the suggestion that the hearing officer needs to review the data. That is not not a precedent that is done in rulemaking hearings. I don't know of any other precedent for that. The technical data is being made available ahead of time. In many times it's made available through the pre-filed testimony, but it's being made available 4 months prior to the hearing. It'll be presented through the parties, and the representations made by Mr. Heiser regarding costs, and doesn't have any basis that we know of, and it's not in line with what we've evaluated for the rules. And really, those are the things that need to come out through the process. And this is an extensive process that we have outlined, and there's sufficient time by any measure of any previous rulemaking here and in other states to develop that. And so it would not be something that the board should hand over to the hearing officer to do.
Madam Chair, may I speak on behalf of my clients? I have not had that opportunity to respond to Mr. Heiser's points.
I think, and let me just double check, Ms. Fox, is it in response? Can you just share what it's in response to what Mr. Heiser had shared?
Yes, in response to his point for requesting for the board not to schedule the hearing and to put that to the hearing officer, and his point about the hearing being premature.
Okay, I think that will be fine, Ms. Fox. Yes, go ahead.
Thank you. As to the first point about not setting the hearing for September 20th, I'd concur with Ms. Katz in her assessment that the 4 months between now and the hearing, and even longer from when the petition was initially filed, is a very long time period for rulemaking. It's very generous. I'd also point out that for the sort of companion hearing before the Oil Conservation Commission, that petition was filed toward the end of October, and that hearing was held the beginning of January. So that was a 2-month process, in between which were, the holidays. And Namogo's was a party in that proceeding as well, and represented by one law firm. And we were able to make all those dates. It was a little hurried and harried, but Namoga is now represented by 3 law firms that are very, very substantial, very experienced law firms. And so I think the time periods are very generous here for this type of rulemaking. And so I would second the department's urging of the EIB to set the hearing for the dates that NMED has proposed. Then second, with respect to whether or not this proceeding is premature, I think Mr. Heiser's objection on those grounds is premature, because what he would need to do if he believes this is premature is to file some kind of a motion with the board for disposition by the hearing officer or the board, something in the nature of a motion to dismiss for failure to state a claim or something along those lines. And so his, observation that this is premature is really of not much consequence right now. He needs to, file what he considers to be an appropriate motion before the hearing officer, to be briefed by the parties and considered by the hearing officer or the board.
Thank you so much, Ms. Fox, Ms. Katz, Mr. Heiser, and everybody's input on the questions that we've had thus far from the board. I do see that Member Cates has another question, and this is as a response to kind of what's been said. Is that correct, Mr. Member Katz?
Yeah, Madam Chairwoman, if I can I just ask a question of Mr. Heiser here directly?
Absolutely. Thank you, Member.
Ms. Heiser, sir. So if you don't want it on September 20th, do you want it a month later? Do you want it a year later? Do you want it to occur in our lifetimes? What can you just give us an idea of what your end game here is in terms of a timeline?
Thank you, Member Cates. Currently, Namoga's preference would be to hold this hearing about 30 days later. That allows our member companies time to give us input from them about what this rule means given the changes. And the other thing we'd like is just a little bit of flexibility in terms of how the schedule is laid out. Thank you for your question.
Yeah, got it. Thank you.
Thank you, Member Cates. Anybody else have, any other board members have any other questions? Okay, if not, Carla, would we be able to go to the next stakeholder?
Yes, I just, Pam let me know that there was a question from, is this a public member, Pam, that you chatted me about?
I believe so. Mr. Fearson?
Okay, I think it would be appropriate if that, Mr. Fearson, if you could pose your question to the board. I don't think it, rather than me paraphrasing it.
Yes, Mr. Fearson.
Sure. Can you hear me?
Yes.
I was just following up with Eric Heiser's comments and commenting on the process so far. On May 6th, when the most recent proposal was released, there was no technical support materials available. And so I had been trying to inquire if what the delay for that was. Because prior to the meeting of today, it would have been beneficial to have been able to review all of the technical support material to ensure that the proposal does represent research that incorporated the appropriate due diligence. And so I do understand that the current plan is to release the technical support material sometime next week or thereafter. I guess I'm just wondering, based on the current process, why that information was not available at the same time that the proposal was released.
Thank you for your comment, Mr. Pearson. I just wanted to have a point of clarification. Carla, was he the other legal counsel that was gonna present or speak on this issue?
I don't believe so. Mr. Pearson, if you could, if you are appearing on behalf of an entity or party or just as a member of the public, if you could state that for the record.
I am a member of the public. I do work for Caterpillar Incorporated. I am not an attorney.
Okay, great. Thank you, Mr. Pearson. And we're just navigating this virtual platform. So I just want to make sure we get everything on record of who's who. And so I appreciate you providing that additional information. So given his comment, I see a member or Madam Vice Chair Trujillo Davis. Yes, do you have a comment?
Yeah, actually, I think that that was a really great question. In our documents that we received, there was reference to a technical document that was completed in 2019, December 2019, it was released. And also that this rule was like a butterfly rule with the MNERD rule. Would we receive copies of that early, like at this time, or is this something that we would receive copies of later? And I guess maybe that's a question for Ms. Katz.
Thank you, Madam Chair and Member Trujillo Davis. So the document that's referred to is the report from the Methane Advisory Panel, and that is already been put out publicly. We will include it as an exhibit in the rulemaking. It's available on the department's website, and it has been for I think around a year. We also, the same is true for the pre-petition draft regulations that we issued back in July of 2020. Those are available on the department's website. We engaged in extensive public outreach, and those we will also include in our testimony as an exhibit at the hearing as part of our testimony on the public outreach that we did prior to bringing the petition. So the board will see all of that. Regarding the technical information, the petition we filed was the preliminary step of invoking the board's formal rulemaking jurisdiction, and the purpose of it was to request that the board set the hearing. We've set the hearing out so far, and we are releasing all of that technical information 4 months ahead of the hearing. There's plenty of time for review of that and to provide comments, to engage with the department on that, and then to provide technical testimony or public comment through the board's hearing process. And anybody can do that. And they can submit direct technical testimony at the end of July. They can wait for the department's direct testimony with all the exhibits to come out and then respond through rebuttal testimony, or they can provide public testimony and comment at the hearing. So 4 months is a really long time. It's plenty of time to review all of that information that we're putting out. It's much longer than other bodies have done for their rulemakings, including, for instance, Colorado in their recent similar type of rulemakings, where they put that out probably 2 months before the hearing that they held. So we think it's plenty sufficient time, and that the reason it's not out right now with the petition is because we're simply trying to get the hearing set, and so that everybody can we can coordinate that, and because we're asking for it so far out.
Thank you, Ms. Katz. Vice Chair Trio Davis, do you have any follow-up on that?
No, I just want to thank you, Ms. Katz, for clarifying the intent of the petition at hand. So thank you very much.
Thank you. All right, I do believe, Carla, that we still have one more that wanted to speak. Is that correct?
Yeah, I'll just call again for what the Council for the Environmental Defense Fund. If anyone's here, if no one's present, then we certainly don't have to wait for that party. But I just wanted to give that party another chance if you're on.
Sure. And who was that? Was that the Elizabeth?
Yes, I have Elizabeth Delone Paranjos.
Okay. Okay, I'm just looking through. Elizabeth, are you here or anybody from your organization or from that organization? All right, I don't see anybody raising their hand. I did have another one. I thought as you were talking, Carla, and Eric, was there, because I had Elizabeth, Miss Fox, Mr. Heiser, and then I had one more.
I believe we've heard from all the parties who formally entered their appearance.
Okay. Okay, great. Appreciate that. I just want to make sure we're not missing anybody. And if there is anybody, I'm gonna take one more look, making sure nobody has their hand raised or, all right. All right. I appreciate all the input from all the parties. I do have do any other members have any other questions? If not, I do have a question for Ms. Katz. So as we scheduled the hearing, you talked about the public notification time requirements. So we're looking at 60 days out that you have to post for the public hearing. Is that, or maybe Pam and Carla too. So that would mean if we're looking at a hearing in September, that it would have to be posted by July. Is that correct?
So, Madam Chair, the way that works is that that notice has to be published in the New Mexico Register, and they have publication dates, and then they only publish on certain dates, and then they have also, you have to submit that like 2 weeks before the publication date. So that's why we have to, I believe that and I don't have the actual schedule before me, but I believe we have to submit that to the New Mexico Register by June 22nd. And so that it would post, publish in time within that 60 days. So that's why I'm saying June for that. And that's why I think we just won't have clarity on exactly where things will be, by the fall with respect to in-person gatherings of that extent. That it's likely to be a lot of people. So my sense is that it would need to be held virtually and published in that way. The notice would need to be published in that way.
Okay, thank you for that. And yeah, I was just trying to get my mind around that, understanding, even as Member Garcia mentioned earlier, there's a very complex and issue that we're about to undertake here with this hearing, and just trying to figure out how best we can make sure that that we follow the right protocols and make sure that we do this appropriately along with the hearing officer.
And Madam Chair, the department will lead the notice. I mean, we would prepare it and we would work with the Office of Public Facilitation to get that through.
Great. Okay. Thanks for that clarification. So I do have one more follow-up question is, this is a very complicated and a lot of different perspectives and stakeholders on this particular issue. Has NMED recently, I know a number of things are happening surrounding this particular effort and initiatives with rule changes. with other boards, has complex issues like this gone forward with rules and regulation changes with other boards and on virtual platforms? And can you share how that has, I guess, how that had proceeded and if it was successful in that in that process?
Yes, Madam Chair. So for instance, as we had mentioned, the Energy and Minerals and Natural Resources Department rulemaking that was, I believe it was in December of 2020, as late fall last year. That was conducted fully virtually and successfully. So the department, I believe you yourself and all of the board members, apart from Member Hunker, were a part of the permit appeals with Wild Earth Guardians. That was a fully virtual hearing. Granted, it was significantly shorter, but the same kind of, I mean, it's the same platform and the same type of, back and forth and multiple parties. I mean, this will be bigger, but I think the board and the department, have examples and have resources that we've worked on to be able to hold those hearings, those virtual hearings successfully.
Thank you so much, Ms. Katz. And legal counsel and Pam, I have another question maybe for you guys. I know, in order to make this meeting happen today, you guys did an extraordinary effort over the last couple of days. Do we have all of that worked out with this platform, or what other platforms would be available for virtual, just so that we make sure as best we can, right? Everything happens. So go ahead.
Chair Sweeney, and the background on that for the other board members, there was a completely technical glitch that was 100% the fault of Zoom. There's no fault on Pam's part or anyone really at the department. We are at this point confident that was a one-time glitch. We were thankfully able to restore this present link around 8:30, 9 o'clock last night. With the lead time that we have for potentially this hearing, I would hope that we don't run into that type of technical glitch. And I believe that you could deliberate which specific platform you all would like to have this hearing. I think we did our last one on Zoom, but I can't remember. I can't remember if it was Zoom or WebEx. So that would be something else for the board to consider at this time, with, of course, the parties' input as well.
Thank you for that. So I just wanted to share that with the other members, just as we figure out how we best move forward on this issue, just so that you have that background as we consider what next steps.
Madam Chair,
yes.
Just if you would indulge one point, and I don't mean to get too creative or too far astray,
Sure.
But perhaps the department or other parties have input on whether, depending on the situation, if the meeting could be, or the hearing could be noticed publicly via online participation, but the board and the parties themselves could appear in person. I'm not a public health person, but if that would be a possibility, if people would prefer that, if people think that's safe, and again, I don't mean to get too far astray, but I think that may be beneficial for the length and breadth of this hearing to do that. But that would still mean that the public itself would be noticed to participate via online.
Thank you for that. Ms. Katz, do you have any input on that?
Thank you, Madam Chair and Board Counsel. I think that is something we could discuss. I think we could evaluate that, and the department could work with Office of Public Facilitation and the board to see if that's workable and to do it that way. I just think we would have to consider that, and that we would, and so then we would need to just do that in the next, few weeks and decide how we wanted to notice it. I think as far as, really the public notice, it mostly needs to be clear with respect to the public and as to how that participation works. So yes, I think that's something we could work with the board and through the hearing officer to explore those possibilities.
Thank you for that. Yes, Member Hunker.
Yeah, that seems to be a process thing that once the hearing is noticed and all the other associated dates, if down the road we decide to modify it somewhat so that we are there in person, et cetera, that seems to be just a modification in form and wouldn't, it seems like we could do a supplemental notice, maintain all the original deadlines. We would just be doing it a little bit differently in terms of some of the parties being there in person. I don't know what do you counselors think, but that seems like a more minor point that wouldn't necessarily impact the overall schedule.
Ms. Katz, I think you had some input on that.
Yes, Member Hunker. So I will say that the public notice requirements are very critical, and we really wouldn't want to create a sort of procedural challenge based on those. If we were to change something, say from a public notice that had a virtual link to in person, I believe the department would not support that type of a change. We would be concerned that it would defeat that public notice. So we would really want the public notice to be, it will need to stay, particularly as it involves the participation of the public. I do think perhaps the parties could agree in some way with the board on some type of in-person aspect, but if it's noticed virtually to the public, it has to be virtual or available virtually. And so, yes, so that would be my input on that.
Thank you for that. Appreciate it. Any other members have any other comments or questions? I think those were the ones that I had for our legal counsels and our the legal counsel from NMED. If not, I would like to, start to move toward a motion regarding this particular item. Do any of our members have any, before I do that, legal counsel, is there anything else that we need to consider schedule-wise or logistics?
No, Madam Chair.
Okay, thank you. So yes, members, just wanting to open up the floor for any motions regarding this this proposal and proposed hearing from the New Mexico Environmental Department.
I have actually one question.
Yes,
It's
Madam Vice Chair.
probably for Carla. Since the meeting or the hearing would be scheduled September 20th, that would go over our regularly scheduled board meeting. Would we need to change a regular September board meeting for another day? How would that work?
If there's other business that presents itself that would require a separate meeting, we could do that. That September meeting is just a held date for your regular scheduled meeting. So if there's no business, we would just have the hearing through that date. And then if another meeting is required for something else, then we would set it appropriately.
Thank you. Yes, Member Garcia?
Go ahead, Member Bitzer.
I just wanted to see, Madam Chair, if it would be appropriate to check back in with Council Heiser, since we covered a lot of ground since he last got called on, and I know they won't necessarily weigh in unless called upon. If there's anything we didn't hear from you since
Yeah.
you last spoke, and the other things that have covered since.
Thank you, Member Bitzer. Yes, Mr. Heiser, do you have any response to Member Bitzer's comment?
Thank you, Member Bitzer. I think that you've heard Namoga's principal concern, and I would just hope that this board would give the hearing officer some leeway in the scheduling to address the needs of the parties. Thank you so much.
Thank you for that, Mr. Heiser. Appreciate it.
Could I follow up to that? What
Yes.
maybe our state attorney general Solorio or counsel from the department, when he's talking about some latitude or some leeway for the hearing officer, how do you interpret that? What would that mean, and would that reconcile with our current motion or the current proposal before us?
Member Bitzer, I believe that the board, could authorize the hearing officer. I think the hearing date is probably something that needs to be decided by the board. I will say that the extra 30 days putting us into October really interferes with a lot of other matters that the department is handling. And it also really pushes into where we start getting into post-hearing briefings that then get derailed by the holidays. And we really, that 30 days is actually not just 30 days, it's like kind of a meaningful time frame that could really end up really pushing things out. And so I would, I think that the board could set the hearing date, and that potentially, if there becomes a serious issue with the schedule, then the parties could come back before the board to deal with that.
Thank you.
My input on that issue, Member Bitzer, is that the threshold question of when the hearing to take place falls squarely within the prerogative of the board itself. And so I don't think that there's, very solid legal grounds to defer that decision to a hearing officer. Because if you frame the issue as if there is, the board has whatever evidence it needs to have before the hearing can take place, I do think that would, in a sense, abdicate the board's responsibility to set the hearing itself. So that's my input on the issue, but of course that the ultimate decision is up to the board.
Thank you for that, Carla and Ms. Katz. Appreciate that. Member Bitzer, do you have any other follow-up on that? Okay, great. Yes, Member Garcia.
Thank you, Madam Chair. Ms. Katz addressed part of my question, which was, it sounds like setting the hearing date and the schedule is sort of one package, but it sounds like, I'm wondering if we set the hearing date, if there's an opportunity for the parties to work out disagreements on the schedule separately. So it sounds like that is a possibility, and that was my question. So thank you very much. I appreciate that. With that, I would be willing to put forth a motion to set the hearing for September 20th for EIB 21-27. And if we need to suggest a hearing officer in the same, if we do a separate motion for the hearing officer, I'm not sure, but I would propose to set the hearing date for September 20th.
Thank you for that. Member Garcia, and I'm gonna look really quick to Carla. Is that okay if we do two separate motions on this?
Yes, yes, Chair.
Okay, thank you.
I'll second it.
Thank you, Member Bitzer, for your second. Ms. Jones, or any other discussion on that before we go to a roll call vote?
Just a, I guess, procedural question. Should we amend the motion to include pre-filed direct testimony due July 28th and pre-filed rebuttal testimony due on September 6th? Or can we do that in a separate motion?
Yes, Carla, can we do that in a separate motion?
You can do it separately unless Member Garcia wants to amend her motion. So you can do it separately.
I'll stick with one motion at a time. So,
Okay, thank you, Member Garcia, for that clarification, and Member Hunker for your also questions, so that we know that, you know, what issues we still have to address in setting this hearing. So if there's no other comment or question on that, I'll look to Ms. Jones, and if you could do a roll call vote.
Yes. This would be for the motion to set the hearing for September 20th. Member Bitzer,
Yes.
Member Cates,
Yes.
Member Duval,
Yes.
Member Garcia,
yes.
Member Trujillo Davis,
Yes.
Member Honker,
Yes.
Chair Sweeney.
Yes.
Madam Chair, the motion passes unanimously.
Thank you, Ms. Jones, for that. So now that we've gotten that passed, can we go on to some of the next items? I think what I'm looking at is hearing officer as well as the schedule. Is there any motion from our board members? Yes, Mr. Hunter?
Yeah, I would make a motion to schedule pre-filed direct testimony to be due on July 28th, 2021, and pre-filed rebuttal testimony due on September 6th, 2021, and that we would hire an experienced hearing officer to conduct the hearing.
Sorry, thank you, Member Hunker. Appreciate that.
Second that?
Second by Member Bitzer. Thank you so much. Is there any other discussion on that motion? Comments from, yes, Member Garcia.
Yeah, we don't need to name the hearing officer?
I'm looking at Ms. Katz and Carla. Do we have to name the hearing officer?
Oh, well, we don't have one a name available, so at this point I would say no. I believe it was discussed that the department has persons on contract, so I don't think there's anything. It's all above board to just have to agree to appoint a hearing officer, and logistically we will select whoever that individual is after this meeting.
Great, thank you for that point of clarification. So with that, I have a motion and a second. If there's no other discussion, I'll look to Ms. Jones for a roll call vote.
Okay, Member Bitzer, how do you vote?
Yes.
Thank you. Member Cates,
Yes.
Member Duval,
Yes.
Member Garcia,
Yes.
Member Trujillo Davis,
Yes.
Member Honker,
Yes.
and Chair Sweeney.
Yes,
The motion passes unanimously, Madam Chair.
thank you so much, Ms. Jones. And so it looks like we have a hearing date of September 20th, our hearing officer to be appointed, and also a schedule through those motions has been set. Is there anything else that do we need to also have a motion on the platform or the process, the virtual versus in person?
Well, I think, Chair Sweeney, I think it's been discussed that for purposes of public participation, it's going to be an online notice. If the board, for the purpose of the record and for the party's own knowledge, wants to vote on which platform they prefer, you can go ahead and do that. And that information will have to be included in the notice, so it may be helpful.
Thank you. Thank you for that, Carla. Appreciate that. So with that said, do we have any discussion or a motion by any board members to clarify the virtual platform? All right. Yeah, I just want to make sure that we clarify how we're going to handle this hearing, just for public participation or clarity for all the various stakeholders as well. So we don't have any procedural issues as well. Yes, Member Bitzer.
Let's just move the discussion forward here. I know it sounds like we had some issues last night with Zoom, but they seem to be working today, and I use them 2 or 3 times a week without issue. So I'll move that we stick with Zoom for these hearings.
Thank you, Member Bitzer.
I'll second.
Thank you, Member Hunker. There's no other discussion. I'm looking at our members. Then I would love to move to a roll call. Ms. Jones.
The motion is to conduct the hearing on September 2nd on the Zoom platform. Member Bitzer, your vote?
Yes.
Thank you.
Pardon me, Ms. Jones, to clarify the motion, the hearing is on September 20th.
I'm sorry. Yes, correct.
Thank you.
Continuing, Member Cates.
Zoom, yes.
Member Duval.
Yes.
Member Garcia.
Yes.
Member Trujillo Davis.
Yes.
Member Honker.
Yes.
And Chair Sweeney.
Yes.
Madam Chair, the motion passes unanimously.
Thank you so much, Ms. Jones. With that, I just want to thank one more time Ms. Katz, Mr. Heiser, Ms. Fox, and I apologize if I forgot anybody, but everybody who's Eric, who's provided input on this issue. I appreciate all your time and energy toward moving this process along. With that, I think.
Madam Chair.
Yes.
I'm sorry to interrupt again. This is Tanis Fox. May I ask 2 points of order, please?
Sure. Yes. Yes, Ms. Fox. Thank you so much.
Thank you, Madam Chair. First, what is the process going to be for appointing a hearing officer? Will the board do that at its next meeting? And then second, what is going to be the process for determining, for purposes of public notice, how the public will participate? Because in the public notice, it'll state the times and places and the methods by which the public can participate, and that will need to be in the public notice.
Thank you for that.
For example, in most hearings of this nature, that are this long, there are specific times during the day that are allowed for the public to participate, like from 8 to 8:30 in the morning, from 5 to 5:30 in the evening, that kind of thing. But what's the process for determining what the public, the opportunities for public comment and notice will be for the purposes of the notice?
Thank you for that question, Ms. Fox. So I'm going to look to Carla and Ms. Katz on that response.
Madam Chair, if I may. So regarding the, I'm sorry, I'm I'm blanking, the process for appointing the hearing officer. The department included a proposed order with its petition that is an order to scheduling the hearing and appointing a hearing officer. And so we would just request that the board issue that order, and it has a blank in for the name of the hearing officer, and the board can simply determine the availability of the department's contract hearing officers. And so long as those are all, which they all are, experienced administrative hearing officers, they can select that and name that in the order that they issue, setting the hearing, setting the schedule, and appointing the hearing officer. And then with respect to the public notice, the parties, once the hearing officer is appointed, then the parties can have a pre-hearing conference to just discuss the structure of how the hearing and the the timeframes that we would want to specify in the public notice that we publish for public comment, and we can simply then include that in the public notice that we publish.
Then will the hearing officer be appointed at the next EIB meeting?
My understanding is that the board simply after this meeting can issue the order that the department put forward, because their motion to appoint a hearing officer, an experienced hearing officer, is granted, so they can simply issue that order after this meeting. I don't believe there's another need for the board to meet to actually appoint the hearing officer.
I'm sorry, I'm just not understanding. So are you saying that the department is then going to select the hearing officer based on your contract hearing officers? I'm sorry, I'm just not understanding how the actual person gets appointed.
The department has hearing officers on contract and so the board is administratively attached to the department. And so they can use our hearing officers, so they can work through our Office of Public Facilitation to get that appointment.
You mean outside the context of an open meeting?
I believe this is the open meeting.
Okay, I am just not understanding how that person gets named.
So Ms. Fox, I think what, if I may sort of clarify this, what I'm hearing you're asking is, right at this meeting, because we don't have a name yet, the board has agreed to appoint, in essence, a professional hearing officer. We don't have the name. And what you're asking is the next step out of, I'm just throwing numbers out, say there's 3 people that contract with or have a contract with NMED. And your question is, how do one of those 3 people get identified? Is that how I'm hearing that?
That's correct. And I think if it's the board if the board will make that decision, obviously, to name the hearing officer, and I believe that has to be done in the context of an open meeting.
So furthermore, with that, so Ms. Katz, I think, is there an internal mechanism within NMED that is like a contractual mechanism with these professional hearing officers? Is that what you're pointing to, I think?
Yes, Madam Chair. So the board chair and Ms. Soloria can work with Ms. Jones to look at our contract hearing officers, determine their availability for that hearing, and can simply name one of them. I think the board has authorized the appointment of one of those contract hearing officers.
And Ms. Katz, if I may just further maybe clarify or ask you this question, is on other matters that required or where other boards have approved of a professional hearing officer, is that the same process that was utilized in order to select that hearing officer?
I believe that process has been used, yes.
Okay. Thank
And my
you.
recommendation would be, and I don't want to play counsel for the board, but to delegate that authority to the chair to appoint the hearing officer.
That's fine if with the department, if that makes procedurally if the board and Ms. Fox more comfortable. I would like that to be delegated now so that we don't have to wait till the board's next meeting, so that that hearing officer can be appointed as soon as possible and that we can get moving on things.
Correct. And I'll just, to clarify where we are, the board has opted to use whomever is available under contract from the NMED. I guess it would be analogous to selecting a particular law firm or the public defender, but not identifying the specific counsel who would work on the matter. So I think that's been clarified. I do think it's, as a matter of procedure, we can take a motion right now to designate or delegate to Chair Sweeney to sign off on the order, which identifies the individual who will be serving as hearing officer.
Thank you for that, Carla and Miss Katz and Ms. Fox for your follow-up questions. Appreciate those. And so given that discussion, I'm going to look to our members. Yes, Member Hunker.
Yes, I was just going to, I guess it's a clarifying motion on the last motion we approved, but I'll move that we delegate or we designate Chair Sweeney to work with NMED staff to designate the hearing officer for this matter.
I'll second that.
Thank you, Member Honker and Member Bitzer. If there's any other discussion on that, I'm looking. If not, Ms. Jones, would you be so kind to do a roll call for us, roll call vote?
Certainly. Member Bitzer, how do you vote?
Yes.
Thank you. Member Cates?
Yes.
Member Duval?
Yes.
Thank you. Member Garcia?
Yes.
Thank you. Member Trujillo Davis?
Yes.
Member Honker?
Yes.
Chair Sweeney?
And I'd like to abstain, just so that, since it's related to my appointment, or to designate myself for this task.
Very good. Then the motion passes with one abstention.
Thank you so much, Ms. Jones. And I believe that, I think we've addressed everything, and I think we can move to the next item, number 5, which is the public hearing, EIB 21-05, in the matter of certification for the 2015 Ozone NAAQS transport, or quote unquote good neighbor provision of the state implementation plan. And we have Mr. Andrew Knight, Counsel for New Mexico Environmental Department, and Daniel Timmons, Counsel for Wild Earth Guardians. And our EIB member, Barry Bitzer, is the hearing officer. That will be the next item on our agenda. And so I have us at 10:32. So legal counsel, at this point, do I just turn it over to Member Bitzer, the meeting, and as a hearing officer?
Yes, Chair Sweeney, and I just wanted to make sure our court reporter is all set to go. She has indicated a thumbs up, so we are set to go. Thank you.
Thank you. And so Member Bitzer, I'll give you the baton here. Go ahead. Thank you so much.
Thank you, Chair Sweeney. This hearing will please come to order. Today is May 28th, 2021. The time is 10:32. My name is Barry Bitzer. I've been designated by the board to serve as the hearing officer, and I will be advised by board counsel from the Office of the Attorney General, Carla Soloria. Can we have the administrator conduct the roll, please?
Certainly. Those in attendance, Chair Bitzer,
Present here.
Member Cates.
Here.
Thank you. Member Duval.
Present.
Thank you. Member Garcia.
Here.
Thank you. Member Trujillo Davis.
Here.
Member Honker.
Here.
Member Sweeney.
Here.
Thank you. All are present, Chair Bitzer.
So with that, we're already an hour and a half into our morning. If it's board's preference, we can power on forward, or if the board would like, or if staff might need to take a 5-minute bathroom break, I'm open to suggestions at this point. Everybody good, or do we want to? Where's the court reporter too? I want to make sure she's good. I don't see her. There she is. We're all good. We'll go forward then. And I will make sure that we address lunch as well. I'll aim for noon for that break and carry on. Meanwhile, this is a hearing in EIB 21-05R to consider the proposed certification by the New Mexico Environment Department that New Mexico has an adequate federally approved state implementation plan that addresses elements of the Clean Air Act, Section 110.2.2, an infrastructure plan, the ISIP, as applicable to the 2015 Ozone National Ambient Air Quality Standard. Due to the COVID-19 public health emergency declared by the governor and following guidelines, public gatherings set out by the Department of Health, this hearing is being held online via the Zoom platform. 20.1.1.306 NMAC does allow for participation via conference, telephone, or other similar device, given all participants are able to hear. If at any point during the hearing technical difficulties arise, please bring them to my attention. Efforts will be made to remedy the situation. The petitioner in this matter is the New Mexico Environment Department, Air Quality Bureau. Wild Earth Guardians also filed a notice of intent to present technical testimony. There will be designated time for any member of the general public to present non-technical testimony. This hearing will be conducted in accordance with the Open Meetings Act, the State Rules Act, the Environmental Improvement Act, the Air Quality Control Act, and with this board's rulemaking procedures. The hearing is being reported by Teresa Dubois from Albuquerque Court Reporting Services. Parties interested in obtaining a copy of the transcript may contact the court reporter directly at the conclusion of the hearing. Copies of the proposed certification have been available on the department's website and at the department's office, as well as to interested parties upon request. The hearing will be conducted in a fair and impartial manner to assure all relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard without making the hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence shall not apply at this hearing or to this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. To that end, I ask all persons at this hearing, please silence their cell phones. During the hearing, please be sure to mute yourself until you wish to speak to help minimize background noise. The hearing shall proceed as follows. Board staff will present pre-filed exhibits. Exhibits admitted into evidence are available for review by the public. All testimony will be taken under oath. As hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious. Any person offering an exhibit shall provide an original to the board, administrator, and a copy to each of the board members and to its legal counsel, and shall also provide additional copies for persons attending the hearing. If visual aids are used, legible copies must be submitted for inclusion in the record. Please know that the board will not make copies of any exhibits used at this hearing. Any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. Petitioners will be present. Petitioner will present its direct testimony on the proposal certification. Wild Earth Guardians will then present its direct testimony on the proposed certification. If any other persons, including members of the public, wish to present non-technical testimony about the proposed certification, they will testify as called upon. If you are a member of the public, please email the board's administrator at pamela.jones@state.nm.us to notify us that you intend to present non-technical testimony and include any exhibits being offered. I'll repeat that. It's Pamela, Pamela, .jones, JONES, @state.nm.us. Because this hearing is being transcribed, please remember that only one person may speak at any one time. Please direct your testimony and answers to questions to the board members. Any person who testifies is subject to cross-examination on the subject matter of his or her testimony and on matters affecting his or her credibility. Petitioner has the option of presenting its witnesses as a panel for purposes of cross-examination. Cross-examination by the other party will be conducted at the conclusion of each presentation, followed by cross-examination by the board members and the hearing officer, followed by cross-examination by the public. Please remember to direct all testimony and answers to questions to the board itself, even if someone other than a board member has asked the witness a question. Any person attending the hearing is entitled to conduct whatever cross-examination is required for a full and true disclosure of matters at issue in the hearing. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. At the petitioner's discretion, and if time permits, rebuttal testimony may be given at the conclusion of the public testimony in the same order as direct testimony. Any person who wishes to make a brief closing argument may do so at the conclusion of the hearing in the same order as the direct testimony. We'll now proceed. Does the board staff have any exhibits to introduce as evidence?
Yes, I do, Chair Bitzer. I have the NMED's petition for the adoption of the state implementation plan certification request for hearing with its attached exhibits numbered 1 through 15. I also have Wild Earth Guardians exhibits 1 through 13.
All righty. That's all the exhibits?
Yes, sir.
All right. Are there any questions from the board members or objections? Seeing none, hearing none. Exhibit 1 through, what number did you say again?
NMED's exhibit 15.
Exhibits 1 through 15 are admitted to the record. If there are no other preliminary matters, we will move to testimony by the petitioner. All right. We'll begin with technical testimony by the petitioner. Does the petitioner wish to make, I'm sorry, go ahead.
Mr. Hearings Officer, oh, go ahead, Mr. Nykiel.
Sorry, my name is Matt Nykiel. I'm here on behalf of Wild Earth Guardians as well. I'll be arguing our side of the case. And I just wanted to be clear, Mr. Hearing Officer, you admitted the NMED's exhibits into the record, and as just another preliminary matter, Counsel for Guardians and Counsel for NMED had discussed beforehand that we didn't have a problem with either of the exhibits that we had offered, and we would also request that Wild Earth Guardians exhibits be admitted into the record, 1 through 13.
If there's no objection or discussion, yes, well, your exhibits will also be admitted to the record. Counsel, have I handled that thoroughly enough?
Correct, Mr. Hearing Officer, and addressing the pre-filed exhibits, the exhibits you've now admitted per Ms. Jones' proffer would be the petition, the notice of hearing, NMED's notice of intent to present technical testimony with associated exhibits, as well as Wild Earth Guardian's notice of intent with associated exhibits. So that should cover everything.
Very well. Thank you, Counsel Timmons, Counsel Nikhil, and Counsel Soloria. Does petitioner wish to now make a brief opening statement?
I do. Thank you. Madam Chair, Mr. Hearing Officer, members of the board, good morning. My name is Andrew Knight. I am the Assistant General Counsel for the New Mexico Environment Department. With me today are Michael Baca, who will be my primary witness, and Kerwin Singleton, who will not offer direct testimony, but he will be part of the panel for cross-examination, and he will be available for possible rebuttal testimony. Now, I would like to make a short opening statement. We didn't plan it this way, but it looks like it is Ozone Day at the EIB. So the hearing before you now is a bit unusual because while we're conducting this pursuant to the rulemaking rules, we are not actually proposing any changes to the air quality regulations. Instead, we are seeking the board's approval of a certification to EPA that our existing rules are sufficient to prevent ozone emissions from New Mexico from significantly affecting downwind states. First, I'd like to introduce a little bit of terminology here. The Clean Air Act requires that we submit to EPA a plan for the implementation, maintenance, and enforcement of the National Ambient Air Quality Standards, or NAAQS. This state implementation plan, or SIP, must include an enforcement program, emission limitations, and control measures. Within 3 years after one of the NAAQS is revised, we are required to submit a so-called infrastructure SIP, or ISIP. And that demonstrates to EPA that we have the regulatory infrastructure to implement, maintain, and enforce the new standard. We can do this in one of two ways, either by certifying that our existing state implementation plan already is sufficient to accommodate the new standard, or by making a substantive revision to our SIP. Now, in addition to our own air quality, the so-called good neighbor provision of the Clean Air Act requires that each state's SIP also prevent emissions that would significantly contribute to non-attainment in another state. In 2015, EPA promulgated a revised National Ambient Air Quality Standard for ozone. There followed years of litigation, with industry saying the new standard was too stringent and NGOs arguing it did not go far enough. This culminated in a DC Circuit opinion in 2019 upholding the new ozone standard. And during those years of litigation and based on EPA guidance, New Mexico did not address the good neighbor provision for the 2015 ozone NAAQS. So what we bring before you today is this last piece. It's our proposed certification that existing New Mexico air regulation infrastructure is sufficient to comply with this good neighbor provision for the new ozone standard. And again, this does not have to do with non-attainment areas inside New Mexico, which is a separate problem, which we are also dealing with, as you just heard earlier this morning. In this hearing, we are only concerned with New Mexico's effect on downwind states. So with that, I'd like to call my first witness and have my witnesses sworn in.
All righty. Ms. Jones, can you, are you the one, or is it the reporter who swears them in?
The court reporter, sir.
All right, Teresa, can you swear Kerwin Singleton and is it Michael Baca in?
Sorry about that. Mr. Singleton and Mr. Baca, will you both raise your right hands to be sworn in, please? Do you both swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you very much.
Petitioner may now present direct testimony on the proposed certification. I guess we've made sure that all exhibits are submitted and numbered. Does the board have any questions? The board members or any, and rule on any objections? Are we okay? Is the board okay where we are at this point? Good. All right, gentlemen, take it away.
Thank you, Mr. Hearing Officer. I'd like to call my first witness, Michael Baca. And Mr. Baca, could you begin by just stating your name for the record and for the court reporter?
Yes, thank you, Andrew. Mr. Hearing Officer, Madam Chair, members of the board, my name is Michael Baca.
And Mr. Baca, for how many years have you worked for the New Mexico Environment Department?
I have worked for the New Mexico Environment Department for over 16 years. And I've worked for approximately 13 years in air quality.
Okay. And did you file pre-filed written testimony in this matter?
Yes, I did. It is included at NMED Exhibit 3.
And are there any changes that you wish to make to that pre-filed written testimony at this point?
There are none.
And so do you adopt that pre-filed written testimony as your testimony here today?
Yes, I do.
And would you provide the board with a summary of that pre-filed written testimony now?
Sure. The department is proposing to certify that the existing United States Environmental Protection Agency approved SIP for New Mexico is adequate as it relates to interstate transport of emissions from New Mexico and their impact on downwind states for the 2015 Ozone National Ambient Air Quality Standards, or what I will refer to as the 2015 Ozone NAAQS. This type of SIP is commonly referred to as a transport or good neighbor SIP and is one of 13 infrastructure SIP elements in the Federal Clean Air Act. These infrastructure SIP elements ensure that air quality management agencies have the basic authorities and capacities to implement, maintain, and enforce a new or revised national standard. In 2015, EPA lowered the level of the Ozone National Ambient Air Quality Standard, triggering the requirement under Section 110A1 of the Clean Air Act for states to submit infrastructure SIPs to EPA within 3 years. In November of 2018, the department submitted its 2015 Ozone NAAQS infrastructure SIP to EPA in the form of a certification. This certification included an evaluation of NMED's air programs and existing SIP for compliance with the applicable requirements under Section 110A2, capital A through capital M of the Clean Air Act. In consultation with our EPA regional office, the department did not address the good neighbor provision under Section 110A2D, Roman numeral 1I. In that submittal, EPA approved the remaining elements of New Mexico's infrastructure SIP for the 2015 Ozone NAAQS with an effective date of October 18th, 2019. Under the Good Neighbor provision, A SIP for a new or revised NAAQS must contain adequate provisions prohibiting any source or other type of emissions activity within the state from emitting air pollutants in amounts that will significantly contribute to non-attainment of or interfere with maintenance of the standard in another state. EPA has addressed the interstate transport requirements of the Good Neighbor provision with respect to prior ozone NAAQS in series of regional regulatory actions dating from 1997 to the present. Through these rulemakings, EPA worked in partnership with states to develop and refine an interstate transport framework to evaluate and address the requirements of the Good Neighbor provision for the ozone NAAQS. Excuse me. NMED used the best information available at the time to analyze the impact of New Mexico's emissions on ozone formation in other states. The department determined that the established four-step framework and EPA modeling data were appropriate for the following reasons. The four-step framework was developed and refined over time in response to rulemakings, public input, and litigation. The modeling and emission inventory development were conducted according to EPA's own guidance, which incorporates the most up-to-date practices and principles. There is no indication that the modeling, associated emissions inventory development, or underlying analyses were conducted improperly or that invalid results were obtained. Additionally, the department does not have the resources or expertise to develop an alternative framework for interstate transport analysis or to conduct photochemical modeling in-house. Although an alternative framework and additional modeling information may be used, there is no precedent for EPA to base a future decision on to approve a SIP submittal. Lastly, the department found that all states relied on the four-step framework and all but one state used EPA's modeling analysis for their Good Neighbor SIP submittals. Using these tools provides a clear, consistent, and equitable forum for EPA to evaluate interstate transport and a state's Good Neighbor obligations. In addition, the department analyzed more information to evaluate the significance of New Mexico's ozone contributions in downwind states. Ozone formation and transport in the Western US is characterized by highly complex topography, localized meteorological phenomena, and long distances between the sources. This holds true in Colorado, where the modeled contributions from New Mexico and other upwind contributors make up a small portion of the design values at the linked receptors. The Colorado source's contributions to ozone concentrations far outweigh those by New Mexico, as well as all other upwind states. The weight of evidence analysis provided in New Mexico's proposed Good Neighbor SIP certification demonstrates that emissions from New Mexico will not significantly contribute to non-attainment or interfere with maintenance of the 2015 ozone NAAQS in any other state. Additionally, the attainment and maintenance issues at the linked receptors are primarily the result of large ozone contributions from the home state, not the small ozone contributions from New Mexico. Hence, further review and analysis for evaluating our interstate impacts under EPA's four-step framework is not warranted. This demonstrates that New Mexico SIP complies with the applicable requirements of Section 110A2D11 for the 2015 ozone NAAQS. Combined with the process, decision-making, and analytical factors discussed right now, these findings provide the department confidence that the board and EPA have a strong technical basis to approve the proposed SIP certification.
All right.
Thank you, Mr. Baca. I have some additional questions for my witness, and then I will turn him over for questions, for cross-examination and questions from the board, if that's all right.
First of all, we'll have cross-examination from Wild Earth Guardians, and then we'll go to the board.
Mr. Hearing Officer, I believe that Mr. Knight has not finished his direct testimony with his witness. So if you want to give him an opportunity to do that before moving on to cross.
Yeah, I'm not implying that we're going there now, because but he was talking about getting questions from the board before Wild Earth had a chance to do their thing.
Understood. Thank you, Mr. Hearing Officer. Mr. Baca, the Environment Department has missed the deadline that EPA has announced for submitting this ISIP. And could you just discuss briefly the circumstances around that deadline and EPA's guidance to us regarding the deadline?
Sure. So as I mentioned previously, the Clean Air Act is triggered when a new or revised standard is set for states to submit infrastructure SIPs to them within 3 years. So that deadline, the original deadline for submittal of infrastructure SIPs was October of 2018. Now, when we began developing the complete infrastructure SIP, we did this in concert with EPA, Region 6 out of Dallas. And so in our discussions with them at that time, this is early 2017, I believe, when we started developing this SIP actually, EPA did not have any modeling information available for us to use at that time. The information that EPA provided to be used in this action was provided in a March 2018 memo. So we did not receive the information from EPA until about 6 or 7 months before the SIP was due. So that's generally not enough time to submit this. So that caused some delay in us submitting the good neighbor provision with the other portion of our infrastructure SIP. So once we finalized all the information, EPA did not get all of the information to states until after the October 1st, 2018 deadline. The last memo that they issued was after that. And so from there, that's when the department finished working on their good neighbor provision through December of 2019. Now we put this SIP certification out for public comment and opportunity for a public hearing. At that time, that's when Wild Earth Guardians requested this public hearing. And so we've been waiting since January of 2020 to actually hold this hearing. Another thing that happened is that the EPA was made aware of that they were going to be sued for a finding of failure to submit these good neighbor SIPs for a number of states throughout the country. Now, EPA published that finding of failure in December of 2019 with an effective date of January of 2020. So that essentially provided a 2-year clock for NMED, the department, to submit and for EPA to approve this submittal before facing sanctions for or implementation of a federal implementation plan. So the original deadline, in short, the original deadline was October of 2018, and due to circumstances beyond the department's control, that deadline has been now set at January of 2022.
January of 2022. Thank you. And so EPA has been aware that New Mexico and 6 other states would not be able to meet the original statutory deadline for submitting this SIP. Is that correct?
That is correct.
And we've been working with EPA throughout the past several years and since the finding of failure to get the SIP ready, and we've been working with EPA to develop a SIP that would be likely to be approved by EPA, although there is no guarantee until we submit the final document. Is that correct?
That is correct. But we have worked with EPA at all steps in this process, keeping them informed regularly, at least on a monthly basis on where we're at with submitting this SIP. They're well aware of what's contained in the SIP, and were part of helping us develop this SIP and allowing us to bounce ideas off them and discuss these ideas and providing more information and support for us to develop this SIP.
And this SIP was developed using EPA's own data, is that right?
That is correct. We used EPA's framework and we used EPA's modeling and emissions inventories.
And we recently received a letter from EPA, I believe it was dated April 26th, that could you, and we didn't include that letter as an exhibit because it was received recently, but could you discuss that April 26th letter from EPA just on a very general level?
Sure. So EPA submitted a comment to the board. They submitted this comment directly to, I think through Pam to the board. And it was basically in support of our SIP proposal today. So they went further to provide more information that more recent modeling that was conducted by EPA now shows that New Mexico is no longer linked to any downwind receptors in any other states. So modeling that they just completed in 2020 now shows that we are no longer linked within that forced framework.
And because we are no longer linked to any downwind receptors, according to EPA's own data, even in the event that that New Mexico failed to submit this ISIP to EPA, or EPA failed to approve it, even in that event, according to EPA's own data, no additional control measures or regulation would be necessary to meet the requirements of the good neighbor provision. Is that correct?
I would interpret it that way. So I would think, it's hard to say what EPA would do, and
sure.
If we fail to submit this SIP, but all indications are that they do not have any evidence or any scientific technical information showing that we do impact any downwind states. So EPA has not been in any discussions with us about our SIP being deficient or that we need to do more in order to meet this requirement.
Thank you. And Mr. Baca, the Wild Earth Guardian's notice of intent alleged that the data that was used to develop this ISIP is outdated. But according to the testimony you just gave, the most recent EPA modeling seems to indicate that we're in an even better position than the earlier modeling that we used to develop the ISIP. Would you say that's accurate?
That is definitely accurate. So EPA used an updated emissions inventory. They used an updated modeling platform in this, and they found that our contribution was most likely overstated in our analysis using the 2011 data as a base year for the modeling. So they found that our link to Colorado was even less than what they had originally concluded.
Mr. Hearing Officer, those are all the questions I have for this witness at this time, and he's now available for cross-examination and then for questions from the board.
Excellent. With that, I'll thank you, Mr. Baca, for your testimony. Look to Wild Earth Guardians now for cross-examination.
Thank you, Mr. Hearing Officer. Good morning, Mr. Baca. My name's Matt Nykiel, and I'm legal counsel with Wild Earth Guardians today. I have a few questions for you. And first, I'd like to start with your testimony about NMED's work with EPA on New Mexico's Good Neighbor SIP certification. In your written testimony, you stated that NMED worked closely with the Dallas EPA regional office during the planning and development of New Mexico's proposed Good Neighbor SIP certification. Is that right?
That is correct.
And NMED's Good Neighbor SIP submission for the 2015 Ozone NAAQS, as you said, was originally due on October 1, 2018.
That is correct.
That October 2018 deadline was a mandatory deadline under the Clean Air Act. Is that right?
That is correct.
And you testified that NMED did not meet that 2018 deadline.
That is correct.
And because of that, we're here now because NMED still hasn't made the required submission for the Good Neighbor SIP.
That is correct.
You also testified that part of NMED's decision not to submit a Good Neighbor SIP in 2018 was based on NMED's discussions with EPA at the time.
That is correct.
But ultimately, EPA issued a formal finding, as you said, that NMED had failed to make a timely submission of its Good Neighbor SIP in 2018.
That is correct.
You also brought up EPA's comment letter that it submitted on April 26, 2021. In that letter, did EPA make a formal determination that New Mexico does not significantly contribute or interfere with downwind ozone NAAQS?
No, they have not.
Okay.
Formal decisions are made via the register, the federal register. So we would be noticed that way. It would be an EPA rulemaking process.
Okay, thank you. I want to turn to another topic, and I'd like to ask you a couple questions about the Clean Air Act and the Good Neighbor provision. Based on your training and experience at NMED, you're familiar with the Clean Air Act, I take it?
Yes, I am.
And the federal regulations that implement the Clean Air Act?
With some of them, yes. I would say nobody knows all of the regulations that implement the Clean Air Act. It is voluminous and nearly impossible for any one person to know those regulations. So without knowing what specific regulations you're referring to, I would say I broadly have a good understanding of how the Clean Air Act works and its implementing regulations.
Okay, fair enough. Thank you. You testified that the Good Neighbor provision of the Clean Air Act has 4 prongs, right?
That is correct.
Would it be fair to say that in general, under the Good Neighbor provision, NMED needs to demonstrate that New Mexico is doing its part to control emissions within New Mexico so that those emissions don't negatively impact the air quality in downwind states?
Can you repeat that question?
Yeah, sure.
I think I'm
Sure, I
understanding
apologize.
it. No problem.
Would you say in general, the Good Neighbor provision, that under the Good Neighbor provision, NMED needs to demonstrate that emissions that are produced in New Mexico are controlled in a way so that those emissions don't negatively impact the NAAQS, the ozone NAAQS in a downwind state?
So your question is, does NMED have the burden to prove that we don't impact someone?
No,
That's the burden of proof to say that we're a good neighbor, or I'm kind of confused by your question. So
yeah,
don't know
no,
if you
I
can have some
apologize.
clarifying statements or.
Yeah, no, I just wanted to get at sort of the general thrust of the Good Neighbor provision. And I can restate it, or I can direct
I can
you.
talk to the Good Neighbor provision. So the prong 1 and 2 of the Good Neighbor provision is what we're here today about. So prong 3 and 4 have already been approved by EPA in our prior submittal. So what we're looking at, prong 1 is significantly. So the keyword in the Clean Air Act, I think, is significantly impact or significantly contribute to non-attainment in downwind states. So that's prong 1. Prong 2 is interfere with maintenance in downwind states. So those are the two prongs that we are evaluating today.
Okay, thank you. In New Mexico, one of the ways that NMED controls emissions so it's not significantly impacting or interfering with the maintenance of a NACS is through the air quality permitting process. Is that right?
That is correct.
And that process includes permitting minor stationary sources?
Yes, it does.
As a matter of practice, when NMED is issuing a permit to a minor stationary source, does NMED evaluate the ozone impacts on neighboring states?
It would depend on what kind of permit that we're issuing. So depending on what kind of program you're looking at, yes, we do. So are you asking for, because we don't have to, I mean, it depends on what permitting program you're talking about.
Yeah, I'm curious about the permitting for a facility, a minor stationary source in, for example, an area that's been designated an attainment like the Permian Basin.
Mr. Hearing Officer, at this point, I would like to object to the cross-examination. It goes beyond the scope of his direct testimony. And Mr. Baca, while extremely knowledgeable in his area, is not our expert on minor source permitting. And I would like to ask council to stay within the scope of the direct testimony.
Mr. Nykiel, counsel, are you, is there some thread that you're going to that brings this back to direct testimony?
Yeah, Mr. Baca's direct testimony, as we were talking about earlier, sort of lays out the process, what the good neighbor provision requires, which is that emissions in New Mexico are not significantly contributing or interfering with the maintenance of the downwind state's ozone NACs. And I think it's important to understand what the rules that are in place to actually control those emissions so that they don't interfere with the downwind state NAC. So I think that the permitting process is a piece of that's important to understand.
Mr. Hearing?
Yes, Mr. Knight.
I'm sorry, Mr. Hearing Officer. Again, to the extent we are discussing requirements for the ISIP, for this particular ISIP, then Mr. Baca can speak to that. But I think the questions that council is asking now are covered by other sections of there are many other sections of our ISIP. And again, if we're going to get into any level of detail about minor source permitting or things like that, this is not the appropriate witness, and this is frankly not the appropriate hearing to discuss those things.
All right, Mr. Nykiel, can you restrict your line of questioning to the specific testimony that Mr. Baca has given?
Yes. Mr. Baca, I'd like to turn to a statement that you made in your testimony about other Western states' good neighbor SIP submittals. You testified that NMED's use of EPA's modeling results that it provided in 2017 and 2018 is consistent with all the other Western states' good neighbor SIP submittals. Is that right? I think you may be on mute.
Sorry for that. That is correct. I went and looked at 13 Western states, or 11 Western states ISIP submittals, and they all used EPA's modeling and EPA's framework for their submittals.
Okay.
That includes Colorado, Arizona, Utah, Wyoming, Montana, Idaho, Washington, Oregon, Nevada, California.
Thank you. You also testified that NMED's use of EPA's modeling results and framework provides a common framework for EPA to conduct its their review of these SIP submissions.
Yes, I did.
Do you know the modeling and data that EPA provided in 2017 and 2018? Do you know if other states received that modeling before New Mexico did?
No, they didn't.
And do you happen to know roughly about when these other Western states submitted their 2015 Ozone NAAQS, or I'm sorry, their 2015 Ozone NAAQS Good Neighbor SIP to EPA?
I do not. I do know that in the finding of failure, there was other Western states that were involved in that. And a lot of that has to do with because if a state is not linked to any receptors, then they basically submit a letter in the form of a letter that their SIP is sufficient to meet the Good Neighbor provisions. So no further analysis is required under the Good Neighbor SIP, as we have done with the New Mexico Environment Department. We provided the certification statement, but we've also provided an analysis because we were linked to downwind receptors. So that's an important point to take note, is that we were linked and that a number of other Western states were not linked.
Okay. Do you know if any other Western states have submitted or are preparing to submit their 2015 Ozone NAAQS Good Neighbor SIP in 2021 this year?
I'm not sure of any other states' deadlines.
Okay.
Or targeted deadlines or timeframes.
Okay, thank you. Mr. Hearing Officer, no further questions.
All righty. Then with that, I'm going to turn it over to the board for any questions. Anybody in the board want to cross-examine the witness? Mr. Honker.
Yeah, Mr. Baca, just one question. Have staff at EPA Region 6 reviewed this proposed certification? And if so, have they given you any feedback as to the likelihood that EPA would approve it?
Yes, they have reviewed our submission, and we did discuss with them any response to comments that we received. And we discussed those comments, and they have reviewed it. They did not provide any formal comments indicating that they have any problems with any portion of our SIP. And orally, they are happy with what we have presented so far, and they believe that this is what would be approvable. And that is the route we followed, is what EPA, we're using their guidance and their assistance in developing the SIP to ensure that what we do submit to them is going to meet what they have told us beforehand, the requirements.
Thank you.
Anyone else from the board have any cross-examination questions? Mr. Cates.
Yeah, Mr. Baca, I don't really have a cross-examination here, but just a question, a point of clarification. I think you said that 6 states are working with EPA along similar lines of what New Mexico is proposing here. And I take it that to mean 6 states regionally, and then you rattled through some there a few minutes ago. I just wonder if you could clarify that, just reiterate that and make sure I'm understanding it. And then I think you also said there's one state that's not doing it, and I kind of wonder which one is that, and whether there's a backstory there that you could share.
Okay. I can take a look, at exhibit. This is exhibit 7J, is the finding of failure. And in that finding of failure, it looks like EPA has named 7 states. So it was New Mexico and 6 others. Let me see if I can find it.
Well, yeah, not to belabor the point, but I just want to, I guess, make sure I understand that New Mexico is not being an outlier here in terms of what it's proposing. Is that
No,
fair
we're
to
not.
say?
That's
Yeah.
fair to say. I would say we are consistent with what other states are submitting, and we're consistent with what EPA has indicated would be the framework that they're going to evaluate our submission under. So I would say,
Yeah, good. Okay, I
doing
just want to
just
make sure I understood that. Yep.
right.
Thank
And I
you.
think my statement, I didn't state that another state is not going to address the good neighbor provision. I just want to clarify that I'm sure they will at some point in time address the good neighbor provision, but a lot of other states were not linked in the 4-step framework. So they stopped their evaluation process really early on and just submitted a letter to cover their good neighbor portion. So like Colorado, for instance, did not provide any analysis showing that they do not impact any downwind states. They solely relied upon EPA's modeling to show that they were not linked to any other downwind states and therefore were not required to provide any other analysis or any other information to show that they do not contribute to non-attainment or interfere with maintenance in other states. So the bar was a little bit lower for other states that are not linked to downwind receptors than if you're linked to downwind receptors, then you have to do another analysis to show whether or not that contribution is significant. And that's what the information we've provided within our proposed good neighbor certification, all those lines of, the weight of evidence analysis is proving that we're not significantly impacting Colorado. Their contribution is 25 parts per billion, when ours is less than 1 part per billion. So that it's clear that the majority of the impact is from the Denver metro area, which is a huge metropolitan area surrounded by mountains and has meteorological conditions that are conducive to recycling of emissions and high ozone formation. The Denver metro area has been non-attainment for every single one of EPA's ozone standards, dating back to 1979.
All right, thank you.
Any other board cross-examination? I'm looking, listening. I have a question. Mr. Baca, you talked about that recent letter, April 26th letter from the EPA, suggesting that we were not linked to downwind receptors any longer. Any speculation or observation off the cuff as to why that might be? Maybe change in the world price of oil, change in weather conditions, improved deployment of technology at the wellhead. Why is that seemingly such a substantial change?
I believe, I could speak to this just slightly. I'm not an expert on the modeling that they did. I'm familiar with it. But I do believe that emissions, although production is going up in the oil and gas sector, overall emissions are down from New Mexico. So when we're looking at, we're looking at the whole of New Mexico from all the source sectors, including electric generating units. We have some units that are going offline, so we're seeing some emissions reductions in the future from that. There's other EPA rules that are on the books that are going to come down. And so I think just as you move further in the forward, emissions always are being reduced. And so as those rules begin to be implemented, you start to see emissions reductions. So for instance, in 2012, EPA promulgated the NSPS Quad O for oil and gas facilities. They also implemented some requirements for engines and other things. So as new sources come online, they come online with newer equipment and better controls. And so just because production's going up doesn't necessarily mean that emissions will likewise go up. It's not a linear relationship because you have to take into account for, you know, the improvements in the inventory methods, but also the control programs that are coming out, declines in older fields, and the economics I think you pointed to is of oil and gas as well play an important role. But economics overall, because it's not just oil and gas, it's the entire suite of emissions coming from New Mexico.
Mr.
All right.
Mr. Baca, may I interrupt? Would you please speak up? You get low sometimes and it's hard for me to hear you.
Sorry about that. I have some new earphones I'm trying out today, so I will keep that in mind. Thank you.
All right, I'm looking at the board again in case anyone else has a question or a cross-examination, I mean. With that, then I'm going to ask if anyone in the audience wishes to cross-examine the witness. Pam, do you see anybody out there?
I don't see anyone unmuting themselves in preparation for speaking. No, sir.
We'll give it a few seconds. I don't want to rush it. You can tell when I unmute myself, sometimes I miss. It's a good thing I don't drive a car with my fingertip on a mouse because I would be crashing into telephone poles. We'll give it a few seconds. All right. So with that, then we're going to now hear testimony from Wild Earth Guardians.
Mr. Hearing Officer?
Yes,
is there
sir.
an opportunity to ask some rebuttal questions, just given Mr. Baca's responses to the board's questions?
That's a good question. I'm going to ask counsel what she thinks.
Within your discretion, Chair Bitzer.
Say that again.
That's within your discretion if you want to allow for follow-up questions given.
Yes, I'm going to go ahead and allow it then, Mr. Nykiel. Let's try to keep it to the point, brief. Mr. Baca, you don't need to give long answers, and please speak up so that the recorder can hear you. But go ahead, Mr. Nykiel.
Thank you, Mr. Hearing Officer. Mr. Baca, I heard you say that in response to one of the board's questions that the EPA has implemented the Quad O NSPS rule. Could you, I didn't understand, well, could you explain that a bit more, please?
In 2012, EPA implemented Quad O. So our SIP is based on 2011 emission inventory. So in 2012, you know, that's just an example of a rule that came into effect after looking at, you know, using this modeling that we're using in our base case. So his question was why we are being, why the new modeling is showing less of a reduction. And I posed to him that could be a number of reasons, including regulations, such as Quad O, you know, any number of suite of regulations that would, you know, number in the 50s to hundreds of regulations that should be coming on board.
Okay, and your understanding is EPA did actually implement that particular regulation?
Yes, Quad O has been in place since 2012. I believe you're trying to hint that Quad O and Quad OA were rescinded. So we've been implementing that regulation since 2012 up and through its recent rescission.
Okay, no further questions. Thank you.
Bam, I ran into the telephone pole again. Wild Earth Guardians, would you like to make an opening statement?
Yes, thank you, Mr. Hearing Officer. Thank you, and Mr. Hearing Officer, Madam Chair, members of the board. Good morning, still in the morning. My name is Matt Nykiel on behalf of Wild Earth Guardians. I'm here with Council Daniel Timmons, as well as our main witness, Mr. Jeremy Nichols. And in today's hearing, Guardians makes 3 requests of this board. Number 1, to find that NMED's Good Neighbor SIP inappropriately relied on outdated data and modeling. Number 2, to find that NMED's SIP does not ensure New Mexico ozone precursors won't interfere with the NACs in New Mexico or its downwind neighbors. And number 3, to direct NMED to address these deficiencies by revising its Good Neighbor SIP accordingly. Wild Earth Guardians is a nonprofit conservation organization whose mission is to protect and restore the wildlife, wild places, wild rivers, and health of the American West. Guardians was founded and is headquartered in Santa Fe, with offices in Denver, Missoula, and Portland, and the organization represents thousands of members and supporters across the West. Guardians has a long history of active participation in air quality matters in New Mexico and the Western United States. The rulemaking today is about being a good neighbor and treating others as we would have them treat us. In particular, the rule must assure our neighbors in states like Texas and Colorado that air pollution from New Mexico won't harm their children, parents, or grandparents by polluting the air they breathe. Just as we wouldn't want our neighbors to take shortcuts or make unreasonable assumptions affecting the people we care about the most, so should New Mexico do its due diligence to ensure we're protecting the people our neighbors care about the most. And it's really in New Mexico's best interest to set the right example so that our neighbors share the same respect and concern when making decisions that affect the air we breathe. Now, to summarize how our testimony will show that NMED's Good Neighbor SIP does not set a neighborly example, first, I want to briefly touch on why rules regulating ozone like this one are so important to public health. Second, I'm going to summarize the 3 types of stale data that NMED based its Good Neighbor SIP on. And third, I'm going to explain why New Mexico's SIP doesn't ensure that ozone precursors produced in New Mexico won't interfere with the NACs in New Mexico or its downwind neighbors. So first, getting to ozone itself. Ozone exposure can seriously harm people, and rules controlling this pollution deserve close attention. Well-documented scientific research confirms ozone exposure can cause respiratory and cardiovascular disease, lower birth weight, decreased lung function in newborns, and premature death. Even short-term exposure can make life a lot harder for folks by exacerbating allergies, asthma, and other respiratory issues. And this is particularly true for low-income and minority communities that are often disproportionately burdened by air pollution. Updated data and modeling have been critical to establishing that ozone can be dangerous to humans at lower and lower concentrations. And updated data and modeling led EPA in 2015 to revise the national ambient air quality standards for ozone down to 70 parts per billion. But despite the importance of up-to-date information, NMED based its proposed Good Neighbor SIP on outdated data and modeling, even though updated data was readily available. Turning to that stale data that NMED relied on for this proposed rule, NMED relied on 3 general types of outdated information. First, the department relied on old air quality data from a period between 2009 and 2013, even though more representative air quality data from 2017 to 2019 was available. And by relying on this older data, NMED's Good Neighbor SIP is blind to the significant ozone degradation that's occurred in New Mexico and in the region just over the past several years. Second, the department's Good Neighbor SIP relied on emissions data from 2011, a decade old at this point, instead of on recent data that reflect the emissions from the boom in oil and gas development in New Mexico and the region. And third, the department's Good Neighbor SIP relied on assumptions that we would see a significant decrease in ozone precursors in the future based on federal pollution controls. But at least 2 of the pollution controls that the Good Neighbor SIP relies on were later rolled back by the Trump administration, and NMED's Good Neighbor SIP does not account for these rollbacks. NMED's reliance on outdated information is really a problem of its own making. Had the department proposed its Good Neighbor SIP by the federal deadline on October 1, 2018, we might not be here today. However, and unlike nearly all of New Mexico's western neighbors, NMED did not submit a Good Neighbor SIP when federal law required it to. And since then, air quality, emissions, and pollution controls have changed significantly. Turning to my final point, New Mexico's SIP doesn't ensure that ozone precursors produced in New Mexico won't interfere with the NACs in New Mexico or its downwind neighbors. In addition to relying on outdated data, NMED also failed to ensure that New Mexico has the necessary air pollution rules in its SIP to prevent harm to its neighbors' air quality. And New Mexico's SIP is inadequate in two key ways. The first is the empirical fact that New Mexico's own air quality with regard to ozone has been degrading over the past 4 years. At the end of 2016, just one air quality monitor in New Mexico showed violations of the 2015 ozone standard. But by the end of 2019, at least 5 monitors outside of the designated non-attainment areas in New Mexico recorded ozone violations. The second key way New Mexico SIP is inadequate is that NMED and this board have interpreted New Mexico SIP in a way that precludes the state from ensuring ozone precursors won't interfere with the NACs. Specifically, during an air quality permit adjudication before this board, in which Guardians was involved, the board agreed with NMED and issued a final order that interpreted New Mexico's SIP as one, not requiring the state to evaluate in portions of the state like the Permian Basin, whether or not a new or modified minor stationary source may cause or contribute to a violation of the ozone NACs. And 2, the department lacks the authority to deny or condition a permit for an individual new or modified minor stationary source in a designated attainment area on the basis that that facility will cause or contribute to a violation of the ozone NACs.
Mr. Nykiel, can I get you to hang on for a second? I'm getting the feeling I should have probably had you sworn in. Because your statements are quite, there's some detail and there's some assertions here rather than just a broad opening statement. Teresa, can you swear Mr. Nykiel in?
Mr. Nykiel, will you please raise your right hand to be sworn in? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Sorry for the interruption.
No, that's fine.
Mr. Hearing Officer, this is Andrew Knight, and I have to raise an objection to counsel for Wild Earth Guardians providing testimony in the first place. The testimony in this matter was to have been pre-filed written testimony, and Mr. Nykiel should definitely not be testifying or appearing as a witness. He was not disclosed as such beforehand, and I think this is inappropriate.
I'm afraid I'm going to have to agree. You'll have a chance at some point, I think, down line here, or someone from your team will, for open comment to bring these points up. But for now, you were supposed to make a brief opening statement and then introduce your witness, Mr. Nichols, if I recall. Yes.
That's right, but Mr. Hearing Officer, I am not a witness or providing testimony. I'm simply outlining the legal basis of where we're coming from and legal findings at this point.
You're presenting new information that wasn't submitted in advance.
This was information we submitted in our pre-hearing statement and notice of intent to present direct technical testimony.
I thought I read it all, but I'm not recalling some of this. Counsel, do you have an opinion about whether I'm going to let Mr. Nykiel continue to go into detail?
how long a lead you want to give Mr. Nykiel as counsel in terms of the representations he's making as opening is up to you. That's really, you can draw the line where you think it's bleeding into testimony that's more properly presented by a witness.
Let me call on Mr. Knight then to point out some specifics that were not submitted in advance that you've heard here so far.
Mr. Hearing Officer, my objection is not that this was not material that was presented previously. My objection is that it's simply inappropriate for a attorney to make factual assertions that the board is going to in any way rely on in making their decision. And if he's, you know, if this material was provided in their notice of intent, then the board certainly has that notice of intent, and the board can read it just like they read any statements in our notice of intent. So you know, if this material was in their notice of intent, I don't see any need to reiterate it now. Especially, you know, again, if he's going anywhere that would you know, suggest that he should be sworn in, then I think that's a red flag right there that we're drifting far into testimony and not an opening statement.
And that may have been my fault. I just, I read through what they submitted, and which took quite some time. And I may not have retained it all. So Mr. Nykiel, how much more time are you requesting at this point for this statement?
Yes, I'm very close to finishing. And just to be clear, I was simply offering legal conclusions that this board has made previously, and not submitting factual assertions.
All right, well, let's go ahead and wrap it up then. I probably took more time than you would have. Sorry. Go ahead.
Thank you. I'm going to start off just a little bit before we paused, but what I was saying was that based on NMED and this board's interpretation of New Mexico SIP, it essentially means that New Mexico SIP does not require the state to evaluate in portions of the state like the Permian Basin whether or not a new or modified minor stationary source may cause or contribute to a violation of the ozone acts. And two, the department lacks the authority to deny or condition a permit for an individual new or modified minor stationary source that will cause or contribute to a violation of the ozone acts. Interpreting New Mexico SIP in this way violates fundamental requirements of the Clean Air Act and limits New Mexico's ability to ensure compliance with the good neighbor provision, as well as the ozone acts within the state. To conclude, ozone pollution can travel both ways, as is the case with New Mexico, Texas, and some of our other Western neighbors. And because of this, we request the board consider the example New Mexico would set for its neighbors if it approved a good neighbor SIP that relied on outdated information and an inadequate SIP. For example, if the board approved New Mexico's good neighbor SIP as proposed, could we expect our neighbors to use up-to-date information when making decisions that affect air quality in New Mexico? Moreover, ozone pollution is a serious regional problem that New Mexico can't solve on its own. So it's in the state's best interest to pay it forward and to make sure our neighbors will work with us to address ozone pollution in good faith. This means New Mexico should do its due diligence and hold itself to the same standards we'd expect of our neighbors. Accordingly, we ask the board to find that NMED's Good Neighbor SIP inappropriately relied on outdated data and modeling. 2, find that NMED SIP does not ensure New Mexico ozone precursors won't interfere with the NACs in New Mexico and in its downwind neighbors. And 3, direct NMED to address these deficiencies by revising its Good Neighbor SIP accordingly. Thank you.
All right, I'm going to ask going forward that we refrain from testifying unless specifically called and scheduled to do so. Wild Earth Guardians, you identified Jeremy Nichols as your technical witness. Mr. Nichols, could you be sworn in by the court reporter? Teresa, can you administer the oath?
Mr. Nichols, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Nichols. Would you please state your name for the record and spell it for the court reporter?
Yes, and if the court reporter can also say if I need to speak up, that would be very helpful. Hopefully I'll be loud enough. My name is Jeremy Nichols, Jeremy Nichols.
Thank you. Would you just briefly state your title and affiliation, please?
Yeah, I'm the Climate and Energy Program Director for Wild Earth Guardians.
Okay, and you submitted signed pre-filed written testimony in this matter, and that's marked as Guardians Corrected Exhibit 1A. Is that right?
Yes, that's correct.
And are you looking at that now?
I do have a copy of my written testimony in front of me.
Okay. Do you adopt this testimony as your testimony today?
I do.
Okay, thank you. Mr. Nichols, did you review NMED's Good Neighbor SIP certification and the materials supporting that?
I did.
And based on your experience, do you have any concerns about NMED's Good Neighbor SIP certification?
Yes, we do have some concerns.
Okay, before we get to your concerns, I'd like to first turn to your experience. Can you tell us about your experience in general and as it relates to air quality, please?
Yeah, so I've been the Climate and Energy Program Director for Wild Earth Guardians for more than 13 years. Prior to that, I founded and directed a clean air advocacy organization it was a nonprofit organization called Rocky Mountain Clean Air Action. And then prior to that, I worked with a conservation organization in Laramie, Wyoming, which is where I got my start on this career track. And in my work in these various capacities as a conservation advocate, air quality regulatory matters have very much been front and center for me, mainly because they relate to my personal mission of advocating for a healthier environment, but also advocating for solutions to the climate crisis. Over the years, I've done a lot of work related to air quality regulatory matters, or air quality proceedings more generally, including regulatory matters, including permitting proceedings, including the development of new policies, and also weighing in even on the development of new laws on both local and state and federal levels. My resume lists some examples of relevant professional engagement. One thing I just want to flag is that I've actually provided technical testimony to this board in the past. In 2007, on behalf of Rocky Mountain Clean Air Action, providing testimony on this board's greenhouse gas reporting rules, which were adopted back then. But I've provided testimony to the Colorado Air Quality Control Commission, drafted and submitted comments to the U.S. Environmental Protection Agency in a number of different proceedings, have scrutinized regulatory proposals, have worked very closely with attorneys and scientists and other experts in weighing in and scrutinizing air quality proposals, be they permitting proposals or, again, regulatory proposals. The focus has been mainly in the Western US, so very familiar with New Mexico and air quality regulation. I think the Environment Department is very aware of my engagement on a number of air quality matters before the agency. And over the years, we've weighed in on a lot of air quality matters before the Environment Department. So very familiar with kind of New Mexico's unique emissions profile and the air quality regulatory challenges facing the state. And very familiar in particular with the proposal that's before this board today, the Good Neighbor provision. We've weighed in on Good Neighbor provisions drafted and submitted on behalf of other states, including Colorado, Wyoming, Utah, and I believe even New Mexico over the years. So definitely have had my hands in the midst of air quality proceedings, and that's where my qualifications lie.
Okay, thank you. Mr. Nichols, would you just kind of briefly explain how you evaluate air quality regulations?
Yeah, thanks for that question. You know, air quality regulatory proceedings take on different forms and are meant to address different Clean Air Act requirements or various air quality challenges. But I think fundamentally we try to bring, or I try to bring a very simple approach. Does the conclusion match the data that was relied upon? Or maybe conversely, does the data that was relied upon support the regulatory conclusion? Be it the adoption of new regulations, or be it the conclusion that current regulations are adequate to demonstrate compliance with the Clean Air Act. And so it's not so much doing the modeling, but really reviewing what data goes into a modeling exercise or other methodologies for determining whether or not a state or even at a federal level, whether air quality regulation is getting the job done.
Okay. And you mentioned earlier that you had some concerns about NMED's proposed Good Neighbor SIP certification. Would you mind just briefly summarizing what those concerns are before we turn to them in detail?
Well, I flagged 3 key concerns in the testimony that I provided. And I think before generally summarizing them, I think they can all be overarchingly summed up as NMED's proposal is not based on up-to-date information and data, that it relies on stale information and stale data. And we're not questioning the validity of the data when it was gathered and when it was utilized by the U.S. Environmental Protection Agency, but that here, where we're at in 2021, that it bears considering this updated data and information. And so my concerns really lie in 3 specific areas. One, whether the EPA's modeling that the Environment Department relied on updated emissions inventory data, and whether it made sense for NMED to rely on inventory data that was prepared in 2011. So that was 10 years ago. We also had a concern over whether the air quality data was up to date enough to support the Environment Department's conclusion. And in particular, what we've seen is that ozone design values in New Mexico and in neighboring states have gone up and seem to be higher than were projected when the EPA did its modeling exercise. And then third, the issue of federal regulations and whether or not they can be counted on to provide the emission reduction benefits that both the Environment Department and the EPA have assumed in their analyses.
Okay, well, let's turn to these each in detail, beginning with the air quality data. Would you tell us about that air quality data that NMED relied on for its Good Neighbor SIP?
Yeah, so the Environment Department relied on modeling prepared by the Environmental Protection Agency. In their initial petition, it was modeling that the EPA had prepared around 2017. I know the Environment Department has since brought forward a new EPA conclusion from 2020, and I'll address that. But I just want to flag that the EPA's modeling data, to the extent that they were looking at the state of air quality, so in other words, what do ozone concentrations look like, both in New Mexico and outside of New Mexico, they looked at design value data that right now is fairly dated. By design value data, I mean data that demonstrates long-term trends in ozone concentrations. There's a design value for purposes of demonstrating compliance with the ambient air quality standards. That's the 3-year average of the 4th highest annual 8-hour reading. And I know that term's come up a bit in proceedings before this board. That design value is really important because if the design value shows a violation of ambient air quality standards, it means that air quality it's not anomalously bad. It's over a longer term period. It has maintained consistently bad conditions. And so it's very reflective of a longer term state of air quality. The EPA also looked at a different kind of design value that wasn't compliance based, but was trying to assess a more normalized trend to inform their modeling exercise. But all that's to say that the data that EPA relied upon was primarily for assessing the state of monitors and the state of air quality of certain monitors was between the years 2014 and 2016. And not to get into that data, but when you compare 2014 to 2016 data with the most recent 3-year period that we are looking at, 2017 to 2019, and I'll just say as an aside, there is 2020 monitoring data, obviously, but when the Environment Department prepared its submission and submitted it, I don't believe that the 2020 data was fully certified yet. So we're looking at 2017 to 2019, and we're seeing big differences. And when you look inside the state of New Mexico, I think that's where those differences become really stark. And I think, as was mentioned earlier, 2014, 2016 design value data showed 1 monitor in violation or in excess of the ambient air quality standards. That was in Doña Ana County, which of course has since been designated a non-attainment area. Fast forward to 2017, 2019, we have 6 total monitors in excess with design values in excess of the ambient air quality standards, including monitors outside of Doña Ana County. Now, the state of air quality in New Mexico is really relevant for this good neighbor provision, because if New Mexico's air is bad, then that means we're affecting neighbors in ways that we didn't previously contemplate and that weren't previously addressed. It goes without saying that if there's excessive air pollution in New Mexico, that it's likely to have an impact on neighboring downwind states. And that bears consideration here. But there are also signs that neighboring states have monitors that are showing higher design values than the EPA assessed when it did its modeling exercise as well, including just over the border in El Paso. Now, we haven't done a complete assessment here, and I'm not offering an assessment of design values as an analytical critique, only an illustrative critique of NMED's reliance on data that is stale. When you look at El Paso, the region now, the design value for monitors in the region are in violation of the ambient air quality standards. That wasn't the case when the EPA did its modeling. That's a changed circumstance that warrants consideration and warrants attention in the department's weight of the evidence analysis. I will just note as well, and we submitted this as a supplemental exhibit, that EPA has actually proposed to designate the El Paso area as a non-attainment area, basically a designated ozone non-attainment area. That's a big change from where things were previously, where it was considered, El Paso was considered to be an attainment area. Now, we focus on El Paso because it is, as we know, right over the border. And it's not to say that New Mexico, I mean, we're not making the determination that the good neighbor provision is being implicated here, but it certainly warrants consideration, especially given that the department's analysis was only limited to looking at the impacts to what they describe as receptors in the Denver metro area of Colorado.
Thank you. Just one other point on what you were talking about with El Paso. Did NMED model air quality in the West Texas portion of the Permian Basin?
Yeah, as I highlighted in my testimony, the EPA's modeling analysis was limited to assessing air quality at actual monitoring sites. And that could be really useful and valuable, particularly for areas in the eastern United States where there's a very extensive ozone monitoring system. But in many places of the western US, and I would include western Texas in that region, there's often large gaps in the monitoring network. They're gaps that may be allowed, but continue to raise concerns in terms of whether air quality is truly being measured to assess whether people are being protected by harmful air pollution. And as I highlighted in my testimony, there are basically no monitors, no ozone monitors in West Texas beyond El Paso. There are monitors in El Paso, but in terms of the region of Texas directly west or east of New Mexico, there are no monitors. And that does raise concerns that perhaps the analysis of New Mexico's impacts in downwind states shouldn't just be limited to monitoring sites, but should also address unmonitored areas. And just to illustrate that point, there's an ozone monitor in Hobbs in Lee County. That monitor is about 5 miles from the Texas border. It seems reasonable to conclude that if the Hobbs monitor is registering high ozone, that it's likely that just over the border in neighboring Texas, that there may be high ozone as well, that New Mexico may be influencing.
Okay, thank you, Mr. Nichols. I want to next turn to emissions data. Would you tell us about your concerns with the emissions data that NMED's Good Neighbor SIP relied on?
Yeah, I mean, to sum it up, I mean, it's data from 2011, and we know the Environment Department, or I know the Environment Department asserts that that's still okay to rely on data that's a decade old, but there are signs that it may not be appropriate and may not be reliable for purposes of demonstrating compliance with the Good Neighbor provision of the Clean Air Act. And in particular, looking at oil and gas emissions. We're all familiar with the fact that oil and gas extraction activities have increased, particularly in the southeast portion of the state, and that emissions are of higher concern. This board actually heard that this morning too with the Ozone Attainment Initiative, which is right now focused on addressing oil and gas industry emissions. The 2011 inventory that was prepared, that it was National Emission Inventory prepared by the U.S. Environmental Protection Agency, they did come up with estimates of oil and gas industry emissions. But when we look at a more recent report prepared actually for the U.S. Bureau of Land Management and the Western Regional Air Partnership by the international consulting firm Ramboll, their projections seem to indicate that emissions are much higher than the 2011 emissions were originally estimated. And I have a comparison in my testimony. I believe it's Exhibit 1A, page 6, demonstrating, and it's fascinating. There have been decreases in emissions according to this Ramboll report, decreases in oil and gas industry emissions. And I just want to be clear, we're not here saying emissions are blowing up and they're beyond what we ever expected. The reality is the projections, which Ramboll looked at, and they looked at 2014 to 2028, for the most part projected reductions in emissions, but the reductions expected by 2028 were still higher than what the EPA relied on in 2011. And I know the Environment Department says, oh, we can't compare the Ramboll report with the National Emissions Inventory, it's totally inappropriate. But we feel it's a very important data point and warrants an assessment by the Environment Department in the interest of assuring that whatever is submitted to the EPA is based on the most up-to-date information. I think that's reasonable to expect when it comes to protecting air quality and ensuring that people are safe from harmful levels of air pollution.
To that Ramboll report, did that report offer any conclusions as to why there was a difference between the National Emissions Inventory that EPA produced and Ramboll's own findings?
Well, there was a separate report, separate from the emissions inventory, that we included with our submission, or I included with my testimony. And they did assess, there were discrepancies between the National Emissions Inventory and emission estimates for, in particular, Colorado and New Mexico, the San Juan Basin of Colorado and New Mexico. And this report prepared for the Bureau of Land Management and the Western Regional Air Partnership, again, tried to assess why were there discrepancies. And there were a few things going on, but one thing in particular that they highlighted was that the National Emissions Inventory did not fully account for minor source emissions, which in the oil and gas sector, there are many minor sources of emissions that the Environment Department oversees. And they found that the National Emissions Inventory took a higher level estimate approach of emissions that didn't reflect the actual minor source emissions inventory. Now that's a data point, and it's illustrative of not the inaccuracy of the National Emissions Inventory, but the need for the Environment Department to be more attentive to other data points beyond the National Emissions Inventory. And that's really, that's our primary concern with these emissions. We're not second guessing the National Emissions Inventory. What we are trying to highlight is that there are other data points, other emissions inventories that warrant consideration by the Environment Department in developing their supporting information, their weight of the evidence analysis for the Good Neighbor submission.
Okay. Mr. Nichols, I want to shift gears one more time and get into the regulatory controls and the concerns you had around that. Would you now turn to that and tell us about your concerns about the regulatory controls that NMED's Good Neighbor SIP is based on?
Yeah, thanks for that question. This came up in the testimony of Michael Baca, the reliance on federal regulations, including the Quado or the new source performance standards for the oil and gas sector. There's also reference to what's called the corporate average fuel economy standards, the CAFE standards, which were expected to reduce emissions from automobiles. And those federal regulations, in particular, the NSPS Quado, Quado A, and the CAFE standards were relied on by the EPA in their modeling exercise. And in an effort to assess what are the projected emission reductions from these rules and what do we expect to see based on the implementation of those rules. And I think many of us are aware that those rules have since been rolled back, that in the fall of 2020, both the NSPS and the CAFE standards were rolled back by the Trump administration. And now the concern is that we don't stand to gain the benefits of those emission reductions, at least for a time. While we hope that those rules come back online and we can achieve the emission benefits that we had hoped for, there is concern that there is a gap that perhaps means that emissions are not what we previously estimated. Those rollbacks warrant consideration, again, by the Environment Department. It's not appropriate from my standpoint to rely on regulations and emission reductions from regulations when those rules actually aren't on the books anymore, or not in the books in the same form that they were previously. It's not to say that the previous benefits that may have been in place from the effectiveness of those rules doesn't matter, but we need to account for present day conditions. And that's what we're expecting here with the Environment Department, and that's what we're not seeing.
And in particular to the new source performance standards for the oil and gas sector, did those rules as they were originally promulgated and under what EPA assumed in its modeling, were those expected to have important impacts for New Mexico?
Yes, absolutely. They were expected to have important impacts for New Mexico. And the Environment Department has said as much.
Okay. Mr. Hearing Officer, may I have permission to share screen Guardians Exhibit number 8, please?
Oh, speaking of which, I'm going to want you guys after the lunch break to read your exhibits into the record, by the way, so just be prepared to do that. Without objection, go ahead.
One quick note, Mr. Hearing Officer, I believe we did admit our exhibits into the record at the beginning of the hearing.
Well, we were approved in block. I just wanted to make sure that yours were numbered specifically.
Okay.
For the record.
Thank you. All right, if my tech skills are with me today, I am going to share.
And while you're doing that, I'm going to ask the board to consider whether they want a half-hour lunch or a full hour. Something to contemplate.
Is everyone able to see my screen? With Guardians Exhibit number 8.
I can see.
Okay. Mr. Nichols, can you identify this exhibit, please?
Yeah, it's a declaration submitted by Elizabeth Bisbee-Keene, the Director of the Air Quality Bureau.
Okay. And would you please essentially direct us to where Ms. Bisbee-Keene had indicated that these rules with the NSPS for the oil and gas sector would impact New Mexico?
Well, in several areas here. Sorry, I'm trying to find my notes. Can you give me just a second?
Yeah, and I can help you too with that.
Yes, if you can help direct me, that would be great.
Yes. Give me one moment.
And I do have a copy of her declaration in front of me.
Okay, great. Can I direct you to
Excuse me, which exhibit is this?
this is Guardians Exhibit number 8.
Thank you.
Yeah. Give me one more moment here. Okay, I'm going to direct you to the PDF page 81. And can I have you please read the first sentence of paragraph 9?
Yeah, in that paragraph 9, Elizabeth Bisbee Keene states, the final rule, therefore, and the reference to the final rule is the Trump administration's rollback of the NSPS for the oil and gas sector, therefore directly undermines New Mexico's public health and environmental investment to reduce VOC emissions that contribute to unhealthy ozone levels.
Thank you. And can you just give a little bit, oh, I'm sorry, the court reporter is flashing her hands.
Yes.
You just need to slow down when you read, please. Thank you.
Thank you very much.
Mr. Nichols, would you just interpret that a bit for us? You started to a little bit the background of what she's stating here.
Well, I think she's stating the real concern, which is that the rollback of the NSPS for the oil and gas sector stood to undermine the ability of states like New Mexico to ensure that ozone forming emissions, particularly volatile organic compound emissions, were kept in check such that public health could be protected both in New Mexico and in the region.
Okay. I'm going to direct you to PDF page 82 now. And would you read the sentence that begins paragraph 12, please?
Yes. NSPS Quad O and Quad OA are fundamental to reducing emissions from the oil and natural gas sector, with any rollback or relaxation of emission standards making it more difficult for New Mexico to keep these counties in attainment.
Okay, thank you. And is there any other summary you want to provide to that statement or to move on?
Well, the counties that she is referring to are the counties that have come up in the context of the Ozone Attainment Initiative, counties that have experienced high ozone levels as a result of expanding oil and gas extraction activities, and where there are real concerns over attainment and the impacts to public health. These primarily include the counties in Northwest New Mexico, in the San Juan Basin, and in Southeast New Mexico in the Permian Basin.
Okay. I'm going to direct you to one final page before we leave this, and that's page 84, PDF page 84. And would you please read the entire paragraph for paragraph 16, please?
Yeah, New Mexico relies upon the NSPS Quad O and Quad OA regulations as they are incorporated into state law to control VOC emissions from small oil and natural gas sources with the goal of mitigating ozone ambient impacts within New Mexico and neighboring states. Without these regulations in place, New Mexico faces adverse public health impacts and a non-attainment designation, including minor and major non-attainment air quality permitting.
Thank you, Mr. Nichols. Is there any other summary you'd like to add to that before we move on?
It just emphasizes our core concern, which is that these rollbacks will have an impact on air quality for the worse, from my perspective, and that those impacts need to be accounted for in demonstrating compliance with the good neighbor provision of the Clean Air Act. We're not in 2011, we're in 2021. Things have changed, and it behooves the Environment Department to account for those changes and to really demonstrate that it is doing its legal duty to prohibit emissions that significantly contribute to non-attainment or interfere with maintenance in downwind states.
Okay, thank you. I'm going to stop sharing my screen now. A couple more questions on this topic. You mentioned earlier, and could you just remind us briefly the rules that EPA's modeling relied on? Which version of the rules did it rely on?
The rules that were in place prior to 2020, prior to the rollbacks, the 2016 CAFE standards and the 2012 NSPS for the oil and gas sector.
Okay. And can you just summarize how you know that that modeling assumed that these older rules would be in place?
In my review of the technical support documentation, that's what the Environmental Protection Agency indicated when they completed their exercise in the 2017 technical support document for the 2017 modeling. And I highlight it in here in footnote 54 on page, forget what page it is in Exhibit 1A, but footnote 54 in my testimony highlights the pages.
Yeah, and the technical support document you're referring to, that's marked as Guardian's Exhibit 5, right?
Yeah, I believe so.
Okay, and one last question here, and you had indicated this also at the beginning. The department's witness, Mr. Baca, pointed to EPA's more recent modeling that it produced for the revised CASPER update. What versions of the new source performance standards for the oil and gas sector and the 2017 CAFE standards, what versions of those rules did that more recent modeling rely on?
Based on my read, the rules that were in place before the rollbacks, the 2020 rollbacks.
Okay. And that's based on your reading of the associated technical support document for that modeling?
Yeah.
And that's marked as Guardian's Exhibit 12. Mr. Nichols, I have one final topic to get at in your testimony today, and I'd like to turn to the department's witness, Michael Baca's testimony that you heard earlier this morning. Do you have Mr. Baca's pre-filed testimony marked as NMED Exhibit 3 in front of you?
I do.
Okay. I need to get that in front of me too. I'd like to direct you to page 4 of his testimony. And towards the bottom of the second paragraph, can you read the sentence starting with NMED used EPA's analytical framework and modeling?
Yeah, so in his testimony, Michael Baca states, NMED used EPA's analytical framework and modeling results for the analysis of ozone transport due to our limited financial resources to contract for and lack of expertise to conduct national photochemical and source apportionment modeling.
And would you go on to the next sentence, please?
Furthermore, this approach is consistent with all of the other Western states' good neighbor SIP submittals. and provides a common framework for EPA to conduct their SIP submission review.
Thank you. And focusing on that second statement, do you agree with that?
Well, I think that it was probably a more valid statement back in 2018 when the SIP submission was originally due, and many states, including many of our neighbors, submitted their good neighbor provisions, SIP submissions to the EPA for review by that 2018 deadline. I think that given the passage of time, there is a very legitimate and real question as to whether that approach solely makes sense, that without being informed by additional new information, updated information, that perhaps even if other Western states may have relied on the EPA's modeling many years ago, that may not be appropriate today. And as for the modeling and the lack of expertise and limited financial resources, I just want to say that the department can conduct a weight of the evidence analysis that accounts for new information and updated information and analysis. We're not asking for the Environment Department, and I don't think they need to conduct a new modeling exercise, but they should at least account for the state of emissions and air quality as it exists today and the state of regulation as it exists today. Otherwise, for one, we want to ensure that public health and clean air are protected as the Clean Air Act intended. But I don't think the department or this board wants to submit a good neighbor provision that is ultimately rejected by the Environmental Protection Agency.
Okay, Mr. Nichols, last topic here. Can you turn to NMED's Exhibit 9D, please?
Yes, I have it here in front of me.
Okay. Would you mind just briefly explaining what it is?
This is one of the memos that the Environment Department points to, one of the EPA memos from 2018, in which they claim that the EPA gave them guidance and supports their good neighbor provision finding that's before us today.
Okay, thank you. And I'm going to direct you just to that very first page. Would you read the first two sentences of the second paragraph, please?
Yeah, the EPA in its memo says, following these recommendations does not ensure that the EPA will approve a SIP revision in all instances where the recommendations are followed, as the guidance may not apply to the facts and circumstances underlying a particular SIP. Final decisions by the EPA to approve a particular SIP revision will only be made based on the requirements of the statute and will only be made following an air agency's final submission of the SIP revision to the EPA and after appropriate notice and opportunity for public review and comment.
Thank you. And would you just, getting a little feedback, I apologize.
That may be Benjamin. Hey, Benjamin, there we go.
Thank you, Mr. Hearing Officer. Mr. Nichols, is there anything you'd like to summarize your thoughts on that statement with?
Well, I think this was affirmed by the Environment Department in their earlier testimony, which is that EPA has not made any kind of a determination that New Mexico's Good Neighbor certification actually meets the Clean Air Act. They've provided guidance, they provided information and analysis, but the EPA has made abundantly clear, not only in this memo, but in other related memos, that states still have an obligation to independently demonstrate that they are complying with the Good Neighbor provision of the Clean Air Act. And that's really important because every state has a unique emissions profile and impacts downwind states in different ways. We can't cast a broad brush and say New Mexico's impacts are going to be the same as Wyoming or Utah or Colorado. It bears assessing details that are more relevant to the state and that truly justify that emissions are being limited consistent with the good neighbor provision of the Clean Air Act. Which is why we feel it's all the more important for the Environment Department to account for updated information and ensure that it is accounting for New Mexico's unique impacts and its unique emissions profile as it demonstrates compliance with the good neighbor provision of the Clean Air Act.
Thank you, Mr. Nichols. No further questions, and I'll release him for further questioning.
All right, well, it's 12:30. Excuse me, it's almost 12:30 now. We didn't take a bathroom break, and we're now well into the lunch hour. I want to keep us on track, so I'm going to propose a half-hour lunch unless somebody objects to that limited amount of time. Seeing no objections, hearing no objections, I'm going to recess this meeting for lunch and reconstitute it at 1 o'clock. Good to go? Excellent.
You're on mute.
Better? Better? Sorry about that. All right, it's 1 o'clock, 1:01 now. We'll get our hearing back underway. I want to thank Wild Earth Guardians for that testimony. I would ask if they're prepared to go ahead and make sure that their exhibits are specifically read into the record numerically.
Yes.
Can you do that? You got a lot of them. So just, and if there's any objections to them, we'll cover those at the end of your reading.
Yeah, thank you, Mr. Hearing Officer. We would ask that Guardians exhibits 1 through 13, including exhibit 1A, are admitted into the record, please.
Hearing no objection, seeing no hand signs towards objection. Exhibits 1 through 13, including 1A, are admitted. So it's department cross-examination time. Does the department wish to cross-examine the witness?
Mr. Hearing Officer, I have no questions for this witness.
Fair enough. Does the board have questions or wish to cross-examine this witness? We got everybody? All right.
Mr. Hearing Officer?
Yeah.
If I may, I would like to ask my witness, Mr. Baca, some rebuttal questions to respond to some of the things that Mr. Nichols said.
All righty, let me take a look here at my agenda, make sure that that's good timing for that. Yeah, go ahead. Is Mr. Baca here too? I had everybody.
Mr. Hearing Officer, before we move on to the department's rebuttal testimony, if you would ask if there's any member of the public who wishes to question this witness.
Indeed. Does anyone else in the audience, including the audience, wish to cross-examine the witness? Pam, you got anybody out there?
I don't have anyone on a list, nor do I see any indication of anyone wishing to cross-examine.
Okay. So we'll give it a few seconds. I know there could be technical challenges. Okay, I'm not hearing or seeing anything. Let's take non-technical testimony now and take written statements from members of the public. Any testimony must be limited to the proposed certification. The board is unable to take any testimony unrelated to the proposed certification.
Mr. Hearing Officer, may I ask my rebuttal questions before we move on to that?
Yes, go ahead.
Thank you. We'll try to keep it fairly short. And Mr. Baca is still sworn in. And the court reporter is ready. We'll proceed. Okay, Mr. Baca, you heard the testimony provided by Wild Earth Guardians, is that correct?
Yes, sir. That is correct.
Okay. About how long has the department been working on this particular infrastructure SIP?
It is going on about 4 years now.
Okay.
That we're going on the infrastructure SIP for the entire the 2015 ozone standard.
And throughout that time, has the department relied on appropriate, accurate, and representative data in their analysis?
I feel that we do. We rely on the best available data at the time that we're doing any analysis. And that is just common practice for us.
And did EPA approve use of that data?
Yes. EPA is the one that's supplying this data to states for states to use in their good neighbor demonstrations or their good neighbor SIP submittals.
Now, is there any requirement for the department to use new data as soon as it becomes available?
No, there is not.
And would that create some practical difficulties in a process like this?
Definitely. You know, I think we live in a world where information comes in quickly. And, you know, information is always changing. So I think, you know, if we don't call at some point in time, we have to say, all right, we're not accepting any more new information and do the analysis. If not, you're in this continual cycle of including updated information, because what we're talking about today is going to be outdated in 3 months if we do an analysis. So, you know, at some point in time, there has to come an end to when you complete your analysis.
And, but having said that, the latest data that you're aware of and as illustrated in the April 26th letter from EPA that was submitted to the board for this hearing is, does the updated modeling show that New Mexico is linked to any receptors in Denver or for that matter, any other state?
No, it does not. The updated modeling is showing that New Mexico is no longer linked to any downwind states.
And
So it
that's
further confirms our conclusion.
Thank you. And that is a determination that is solely in the purview of EPA, is that correct?
That is correct.
And was the updated modeling that we're talking about, was that based on more recent inventory years?
Yes, it was. So the platform that EPA used for the updated modeling was a 2016 inventory platform that they used. So it was updated.
Okay. And is New Mexico's reliance on EPA data and only EPA data, is that consistent with what was done in other states as far as you know?
It is consistent with other states, the majority of other states. There, like I said in my testimony earlier, there was only one state that I found that used their own modeling for this, but they decided to use the framework with their own modeling.
Okay. And Wild Earth Guardians has criticized the department for using, as they call it, stale data, and not using data that has come out in very recently. But if not for Wild Earth Guardians' request for hearing, when would this SIP submittal have been submitted to EPA?
So absent the public hearing request, we would have submitted this certification to EPA in January of 2020. So roughly 17 or 18 months ago, we would have submitted this SIP submittal.
And this transport SIP has nothing to do with ozone concentrations measured within the state. Is that correct?
That is correct. So this action solely has to do with our impact on downwind states and what obligation we have as a good neighbor to address those emissions.
And let's see, according to the EPA, did the rollback in CAFE standards impact NOx and VOC in New Mexico?
No, they did not. The CAFE standards apply to greenhouse gases and fuel efficiency. They do not apply to the precursor emissions of NOx and VOC. So the CAFE standards, they're not covered by that. The Tier 3 rules for vehicles cover NOx and VOC emissions.
Okay.
And those rules are still on the books today.
Let's see. And the Wild Earth Guardians was discussing the RAP emissions inventory, and that it's different from the modeling results that EPA provided. Do you know if EPA was aware of those differences between RAP's results and their own?
Yes, they are. EPA is aware and RAP is aware, and they've been working together. The emissions inventory development and modeling world is a close-knit world. There are, only a handful of people in the country that are truly qualified to be conducting this type of work. So they all talk to each other. They all compare inventories. So RAP and EPA are aware of the discrepancies. They've evaluated those discrepancies and found that some of the differences are simply due to the way they compiled inventories, such as putting certain sources in oil and gas while EPA put them in another source category. So some of those discrepancies have been looked at by EPA and RAP, and they are aware of those issues.
And I guess maybe the larger question, or the larger point, emissions inventories by themselves don't really tell you anything about New Mexico's effect on downwind states. Isn't that correct?
That is correct. The way that you can actually evaluate someone's impact, you have to have modeling results associated with those emissions. And it's the entirety of the emissions. So it's not only for one source sector, it would be for all of the emissions from the state of New Mexico, including vehicles, biogenics, industrial point sources, electric generating units, household, solvents, and numerous different sources.
Okay, I think that's all the questions I have. And my witness is available for cross-examination of his rebuttal testimony and further questions from the board, Mr. Hearing Officer.
Thank you. All right, I'm going to revisit public testimony here real quick. We are now prepared to take any brief opening statements from the public, direct testimony on the proposed certification. Do we have any direct testimony lingering, Ms. Jones?
I see no one indicating that they wish to speak, Mr. Chair.
Okay. Nobody's submitting any exhibits. Carla?
Yes, I was about to ask Pam if she had received any exhibits or commenters via email as announced at the opening of the hearing.
No, I've received nothing via email or mail. No documents.
Well, that makes it easy. So we're going to get down to the board. Does the board have any questions or wish to cross-examine this witness? Karen, let's start with you. Sorry, Member Garcia. I'm getting all casual here.
Thank you. Thank you, Mr. Hearing Officer. I do have a question for the witness. Mr. Baca, well, sort of getting to the crux of the issue, it seems like one of the most outstanding issues that Wild Earth Guardians has a problem with is whether the data used is outdated or not. And I understand your questioning just now, Mr. Knight, was directed at that issue. However, let me ask Mr. Baca, since Wild Earth Guardians is suggesting that there could have been more updated data used and that it may have given some different information or different conclusion. And I understand your response to that is basically, well, we have to pick a point in time. We pick a point in time, we use the data, EPA is good with that. They agree with the data we used and they're fine with how we did it and the modeling, et cetera. I get that. However, could you have used more updated data? I mean, there's a lot of different timeframes of data that has been discussed, 2017 to 2019, et cetera. I'm wondering, could you have used something more updated, more recent than you did? And would EPA have had a problem with that?
So we are free to choose the sources of data that we use in the way that we submit SIPs to EPA. So long as they meet the Clean Air Act, then we can proceed in any fashion that we see fit. But speaking to that, we would want to follow the method that EPA has shown. So let me see, I'm trying to address. Can you repeat your question again so I make sure I got that down?
Sure. So I'm just trying to deal with the issue of Wild Earth Guardian suggesting that the data you use for the modeling is outdated. So therefore, I'm asking you, could you have used something more recent? I know you picked a point in time and you used that data and EPA is okay with it, but could you have used something more recent? Is there some reason why you didn't?
There was no other information available to us at the time that we proposed the SIP for public comment. So that would be back in December of, well, you know, we're developing this SIP all through 2018, 2019. But in December 2019, there was no other modeling information out there for us to use to develop this SIP. And one point to make about emissions inventories and modeling is that you're always doing a retrospective look at a base year. And it takes years to develop emissions inventories. So like for instance, the updated modeling that was done in 2019 and 2020 by EPA is using the 2016 base year. So it's using a base year that's even 3 to 5 years prior to the time that you start these exercises. So you're always using some sort of outdated or still data in your base case, because what the model is trying to do is take those emissions and see how well it works compared to monitored data. So you're basically, with that base case run, you are trying to calibrate that model to get the correct answers for the correct reasons based on monitored observations. And so that assertion that it's stale or outdated doesn't hold weight with modeling, because what you're trying to do is, can you reproduce the past with the emission inventory that you have developed? And what EPA found is that their model performed within the guidance, that it was getting the right answers for the right reasons. And so that's what's called a model performance evaluation. And so they found that their 2011 base case was running correctly. And then they project those emissions inventories in the future based on assumptions. So all future year emissions inventories are going to have assumptions and estimates and stuff built into them that is going to lead you to different answers based on the methods that you compile these base case emissions inventories, and then the methods for projecting those to a future year.
Thank you. Thank you very much. You're muted. Mr. Hearing Officer, you're muted.
Member Trujillo Davis. You have cross-examination for the board, I mean for the witness?
Yes, thank you. It's for Mr. Baca. I was just curious, when new data comes out or becomes available, does that have to be certified, or is there like a certification process for data to verify it and make sure that it meets a certain standard?
Sure. For monitoring data, there is a process for that. So monitoring data, there's usually about a 6-month delay between the time that between the end of the year and the time that data is actually published. So states have until May 1st of the following year to certify their data. And then EPA, once that's certified, it becomes official data in May of the following year. Then EPA takes that certified data and calculates design values, and those are usually issued late June, early July. So you're looking for about a 6-month delay between the collection of the data for the year and between the time it actually becomes official data. Now, emissions inventories are never really considered official data. That is left up to whoever's conducting the study or developing the emission inventory to do the methods in accordance with EPA guidance, or it's mostly with EPA guidance, because nobody conducts emissions inventories or modeling outside of EPA guidance, because then it's an academic study and not a regulatory type of issue.
Thank you. That's the only question I had.
Other board cross-examination questions? All right, let's move forward then.
Mr. Hearing Officer, I apologize. I think I may have been confused. When you moved into receiving public comment, I thought you were going to come back around and allow cross-examination for guardians, but I may have misunderstood.
We didn't have any public input, but you would like to cross-examine?
Just briefly.
Let's go ahead and do that.
Mr. Baca, you said that EPA approved the state's use of the data it provided for the Ozone Good Neighbors SIP. Did the EPA issue a formal approval to New Mexico to use that data in 2021?
I'm not sure what you're referring to, that I said EPA approved use of data.
Yeah.
Can you give some context to that?
In your rebuttal, you mentioned that the EPA approved the state's in general use of its modeling data I believe you were referring to the 2017 and 2018 guidance memoranda.
So did EPA, no, I mean, EPA has not issued any formal approval. They've issued the memo that says this is what states are, can use to develop this framework. This is what EPA is familiar with. This is the information we have provided you with. Now feel free to use this information as you see fit.
Right. And that EPA said that in the context of meeting the federal October 1st, 2018 deadline, right?
They said that in context of meeting the Clean Air Act Good Neighbor provision.
Okay. The other question I had for you is, you mentioned that fuel efficiency doesn't impact ozone precursors.
I didn't say that. I said the CAFE standards apply to greenhouse gases and fuel efficiency standards, and that there's another rule, the Tier 3 standards, that apply to emissions of NOx and VOCs for vehicles. That's the rule so there's two separate rules for vehicles that I'm talking about here. One is the CAFE standards and one is the Tier 3 standards.
Mm-hmm. But the CAFE standards apply, the CAFE standards set the fuel efficiency that different model years of cars must meet each year, right?
For fuel efficiency, yes.
Right. And so
it does not set what the VOC or NOx emissions coming out of the tailpipe are.
Okay, I see. But you would agree that the vehicles, they emit ozone precursors when they burn gasoline or oil or diesel.
Yes.
Okay. And so if the fuel efficiencies, depending on what the fuel efficiency standard is, a particular model year of a vehicle is burning more or less gasoline or diesel or oil, right?
I guess we're getting pretty hypothetical here. I guess hypothetically, yes. But if the vehicle's not maintained properly, then all sorts of things can happen with emissions.
Okay. And the 2017 corporate average fuel economy standards, they had initially set fuel efficiency at 5% annually. Is that right?
Yes.
Okay. And then those efficiency standards were later revised so that each model year car no longer had to meet 5% efficiency, but instead 1.5% annually. Is that right?
Mr. Hearing Officer, I'm going to have to object. This is beyond the scope of his rebuttal testimony, and it's outside of his area of expertise. And we didn't provide any testimony on the specifics of CAFE standards.
Mr. Hearing
Indeed.
Officer, I'm simply getting at, Mr. Baca had said that fuel efficiency standards don't apply to ozone precursors. And so I'm just questioning him on that point.
I never said that. I said that CAFE standards apply to greenhouse gases and fuel efficiency. EPA has a separate rule that applies to VOC and NOx emissions from tailpipes from vehicles. There's two separate rules you're getting mixed together, and you're confusing the two rules, seems like to me. EPA still has Tier 3 standards in place for NOx and VOC emissions.
All right, Mr. Nykiel, do you have any other questions?
I'll leave it at that. Thank you.
All right. All right, we are at the point of closing arguments.
Mr. Hearing
Uh-oh.
Officer, before we move on to closing arguments, can I just make a statement for completeness of the record?
Absolutely.
It came to my attention that there had been a public comment filed, not recently. Let me just share it so that. This was received by the board administrator. It's file stamped April 26th, and it was posted on the website for some time now, but it was not admitted earlier when we opened the hearing. So I would just like to proffer this for admission if there's no objection, since it was previously received by the board.
Yes, indeed, I recognize it. All right, is there, if there's no objection, we'll include this as under what category of exhibit and what number?
It would be the board's, stop sharing this. I would do board's exhibit 5.
Well, there we go. If there's no objection, we'll include this as board's exhibit number 5. Seeing none and hearing none, I think we're ready to move on to closing arguments. Except that from 505, 577, 6178, I heard something briefly. Were you trying to get in? (577-6178), that New Mexico phone number. So I guess somebody unmuted accidentally briefly. All right, let's go to closing arguments then. Any person who testified and who wishes to make a brief closing argument may now do so in the same order as direct testimony. We'll start with the petitioner, followed by Wild Earth Guardians, and then any members of the public that we may have missed.
Mr. Hearing Officer, I assume you mean closing arguments from the attorneys?
Yes.
Thank you.
Is your attorney handy? I don't see her.
Mr. Hearing Officer, Madam Chair, members of the board, thank you for hearing our testimony today. Wild Earth Guardians used a lot of words like maybe and perhaps or it's likely or they're concerned, and we appreciate their concern, and we share their concern for New Mexico to meet its obligations under the Good Neighbor provision. The bottom line is, although they express concerns, neither they nor anyone else has presented any evidence today to show that New Mexico is having any substantial effect or any significant effect on ozone concentrations in downwind states. And in fact, the latest modeling from EPA shows, as you've heard in testimony and as you've seen in the exhibits, the latest modeling shows that we are no longer linked to any receptors in any downwind states, and therefore it is physically impossible for us to, for it to be determined that we are having a significant effect on downwind states for ozone. Therefore, our certification, which is what we are submitting today, our certification, while I will not speculate as to EPA's final action. However, given everything that we've been doing the past several years on this and the work we've done with EPA, we are very confident that our certification will be approved by EPA. And we see no reason at this time to make any change to it based on the latest data that we have. And we think we've done everything properly and we've checked all the boxes. And so we asked the board today to approve this certification so that we can submit it in a timely fashion to EPA. The approval process through them is going to take some time. And at this point, I think if we submit it now, we can be reasonably certain that we will make the January 2022 deadline for EPA to approve it and thus avoid a federal implementation plan, which is something I think everyone would like to avoid. So with that, we ask the board's approval. And thank you again for your time today.
All right, Wild Earth Guardians, closing arguments, please.
Yeah, thank you, Mr. Hearing Officer, Madam Chair, members of the board. It is Ozone Day today, and there's a bit of a discrepancy I think we all heard. Ms. Katz had started the day explaining that there is a problem with New Mexico's air quality regulations when it comes to ozone, and that there needs to be something done about it, and the department's working on it. And then on the other side of things, in this hearing today, this part of the hearing today, we have NMED saying stamp of approval, the SIP is sufficient to prevent air quality degradation in our downwind neighbors. And I think Mr. Nichols explained some reasons why that is not necessarily, may not necessarily be the case, and there's information that the department needs to follow up on. So Mr. Nichols talked about the air quality data and how it's changed in just the last 4 years, and how emissions data, the data NMED relied on, is about a decade old. And we have a lot more information showing that minor sources may not have been, that minor sources deserve a closer look. And then finally, that the federal regulatory controls have changed since EPA's modeling was initially done, and which is the modeling that NMED relied on here. And as you saw, even the department has shown that those federal regulatory controls were critical to New Mexico protecting itself and its downwind neighbors from ozone violations. So this as someone mentioned earlier, these air quality regulations get wonky quick, and I just want to bring us down to earth briefly, that at the end of the day, the board is considering a rule that impacts human health. And as I said at my opening, ozone can really harm people, ranging from exacerbating allergies or asthma, which is no small thing this time of year, to complications with newborns and premature death. And it's important that New Mexico take the time and use updated data, not only because it's the right thing and in accordance with the law, but we also want to set an example for other states that may be making similar determinations that affect our air quality when they're emitting things that come downwind into New Mexico. So I think it behooves this board to consider what we teach our kids, that you treat others as you would want to treat, as you treat others as you'd want them to treat yourself. And we would ask the board that it find that NMED's Good Neighbor SIP in this case inappropriately relied on outdated data and modeling, that the SIP that NMED's Good Neighbor SIP does not ensure that ozone precursors produced in New Mexico won't impact ozone, the ozone NACs in state and in its downwind neighbors. And finally, that it direct the board to address these deficiencies accordingly. Thank you.
All right. There was no public comment pending, yes, Ms. Dubois? There's nobody waiting in the public to make a closing argument?
No one, sir.
No one's out there. I'm sorry. I'm asking the wrong person. So with that, then I would like to thank the board, Wild Earth Guardians, and everyone present for their participation today, and the state and the Attorney General. The hearing notice indicated that a decision might be made at the conclusion of this meeting, of this hearing. The board may immediately deliberate and decide on the proposed regulatory changes at the conclusion of the hearing. So with that, the record of this hearing is now closed. Let the record show that the hearing adjourned at 1:39 p.m. And record of this public hearing. There's a reason stated as to why the record should remain open. Has anyone stated a reason?
Mr. Hearing Officer, I think the script you're referencing might be a little bit confusing at this point. The notice stated that the board, if it so elects, can choose to deliberate today. There are a number of options. You can close the record, have the board deliberate today and come to a decision. You can keep the record open if the board and you as hearing officer elect to have the parties submit proposed statements of reasons. And that if that were the case, you would leave the record open. We would leave here today and we would meet at a later date to deliberate with those proposed statements in hand. Another option would be, in addition to the proposed statements of reasons, the board can designate the hearing officer to also compile a report and recommendation. So that if you would like to poll the board on those options, that's up to you. But those are all available at this point.
I would very much. Thank you. So opening this up to members of the board, what's on your hearts? What are you thinking? Board Member Garcia.
I'm willing to go ahead and deliberate today.
I am as well.
Okay, that's
Yeah,
two.
I am as well, Chair Bitzer.
That's three.
I am as well. I think we got a very thorough discussion of the issues in the advanced materials and the discussion today, and like to thank the parties for that very thorough discussion. But I think it's unlikely that we get any further information, leaving the record open. So I'm ready to deliberate as well.
All right.
I agree.
I agree as well.
Seems to be unanimous. So I'm going to close the record. Yes, counsel, is that my prerogative at this point?
Yes.
All right, I'm going to go ahead and close the record. I want to thank everybody for their participation. Let the record show, the amended record show, or the ongoing, that hearing was adjourned at 1:42. So we can now deliberate, yes?
Correct. And the court reporter is released, but we do have to keep the Zoom recording on so that there is an audio recording of the deliberations.
All right. Well, I want to thank Teresa for her service. And I don't think I'm the one to be doing this at this point. I think I turn this back over to Chair Sweeney, right?
You can, if that's That's between the two of you. I think technically, yes, you are the hearing officer and that your hearing has concluded. So if Chair Sweeney wants to take back the baton, that is her prerogative.
All right, Chair Sweeney, I'm at your beck and call.
Thank you, Member Bitzer, for being the hearing officer and conducting our hearing today. I appreciate your service and all the preparation on that. So it looks like I'm looking at the Member Bitzer closed the hearing. So since all of us, that's a unanimous one, wanted to deliberate on this this topic that we had today, we go back to our agenda. So with that said, I would love to open it up and hear the comments of our board on this issue. And then maybe, or if there are no major comments, discuss about any motions on this issue. So I look into our fellow board members, my fellow board members, if you have any comments or input. Right. Oh, Member Garcia. Yes.
Thank you, Madam Chair. I guess my comment would be I appreciate the information that Wild Earth Guardians has provided, and I truly appreciate the wish for New Mexico to be as good as we can possibly be, and make sure that we're not negatively impacting downwind states or any other neighbors. And I can see that the air quality regulations are very complicated, and EPA processes are very complicated. And what I gather today is that in light of all the requirements and complications of the EPA process, the department did everything they were supposed to do. Whether they could have gone further, I guess is always a question for any environmental department, I suppose. But considering that they followed all the procedures and protocols and modeling requirements, I feel it makes sense to go ahead and approve the SIP in my mind. But I do, at least that's my opinion, but I do appreciate that Wild Earth Guardians has brought this to our attention and is trying to do everything they can to clean up the air over New Mexico. I appreciate that. That's all.
Thank you, Member Garcia, for your words, and I echo that as well. Yes, Member Hunker.
Yes, I agree with Member Garcia. I certainly understand Wild Earth Guardian's standpoint and concern that there's more data. You always want to use the latest data, but we also need to recognize that these are processes that take time. As was mentioned, things are always changing. Yes, the last national administration backed off on some rules, but some of that will probably be reversed. And the air rules that we discussed earlier in this meeting that we're going to have a hearing on in September will impact this whole issue. But I think NMED has followed the EPA guidance. They've used the process that EPA set forth. And I'm comfortable moving forward with approving this certification.
Thank you, Member Honker. Appreciate your words as well. Any other members have anything else to add or voice
Yeah,
as we?
yeah, Chair Sweeney, may I?
Yes, absolutely. Member Hall.
I'll offer a slightly different opinion as someone that's actually done some of this modeling work. I'm squarely on the side of Wild Earth Guardians because it really is not all that burdensome to update databases, using computer code that's scrubbing websites. I mean, it's basically as soon as the data comes out, those models can get repopulated. I would personally like to see a little bit more about how validation was done, how calibration was done, if they used any type, like what was their validation scheme. So I don't find what Wild Earth Guardians is asking for to be overly burdensome, especially given computing power these days. It's without a much more technical explanation of what they were doing. The frameworks that I'm familiar with, it does not seem like that heavy of a lift to be using more up-to-date data. So I don't want to throw that out as somebody that is, I wouldn't say I'm an expert in the field, but I'm definitely knowledgeable of the field.
Thank you for that, Member Duval, and it's great to know and hear that we have members of the board that have in-depth experience with some of these technical issues and models that we're talking about today. So I appreciate that perspective as well. Yes, Member Bitzer.
I want to sort of second Member Duval's point about how in a 21st century digitally dynamic environment, it should be pretty easy to upgrade these things, update them. But however, the tangle that I see isn't so much with the massaging of the data or the updating of the data so much as it is the bureaucratic timeline that we're now up against. So that's my overriding concern that I hadn't really heard aired yet. Otherwise, I think you've all made valid points.
Thank you for that, Member Bitzer. And yeah, yes, the timelines that we're all regulatorily and compliantly trying to deal with as well as good consideration. Member Kate, I saw your hand up a few minutes ago.
Yeah, I would just, I don't have anything really original to say beyond what has already been said, other than to reiterate that I really do respect Wild Earth Guardians' commitment to a more complete data, their desire, their commitment to require a more complete data set. I think everybody wants to see that. And that said, the fact that New Mexico is not an outlier here, not proposing anything anything remotely radical or really irresponsible to my mind, makes me want to do what the state is asking. So thanks everyone for submitting testimony.
Thank you, Member Cates. I appreciate that as well. Yes, Vice Chair Trujillo Davis.
I think I'm the last one to go and make comments here. So, so again, I don't think I have too much original to say here, but I'd like to offer support in the thoughts that, it is always best to have the most updated data that is that can support the situation that we're currently in. And however, I think facing the deadlines that we're currently facing, and that we have the support of, that NMED has the support of EPA at this time with what they have done. I think that I'm going to have to support NMED on their submission of the SIP.
Thank you for that, Madam Vice Chair Trujillo Davis. I appreciate that. Anybody else, any other member have any other comments? Yes, Member Honker.
Just a question, I guess. If we were to go ahead and do what NMED has requested us to do in the petition, could we also tack on a recommendation that NMED improve their ability to utilize current data in future certifications, or some sort of a recommendation or urging for to kind of make this situation better the next time this comes around? Is that a possibility?
Board counsel, do you have any response to that or input?
Yes, to Member Honker and Chair Sweeney, I would advise that in its final decision, the board is limited to the four corners of the petition and the relief that was requested in the petition. So I would caution against making any other collateral recommendations, but would also advise that, of course, the board members' comments have been made part of the record of these deliberations and have been witnessed, as you've seen, by the parties who are present here.
Thank you so much for that. Yes, Member Trujillo Davis.
So we've discussed a couple of times the upcoming deadline, and we've discussed what would happen in that case of going into a FIP, a federal implementation plan. But I'm not sure I truly understand the impact of a FIP in this particular situation. Can we ask that question, or can that be clarified for us? Member Honker, would you have some insight on that?
I'm afraid I can't help, not having worked in the air planning program in my experience.
Thank you for that, Vice Chair Trujillo Davis. Legal counsel, board counsel, is there a way where we could address that, or is it that the hearing is closed and we can't reopen?
Right. The record is closed, so we can't ask the parties to present testimony at this point on that. There is a provision in the rules that you could, at this point, leave the record open, but that would imply that you'd have to come back again. So the rules do allow, if in the course of your deliberations there are facts that you think should be further explored, you can do that. But that's with the understanding that you would pause the deliberations to obtain that information.
And so maybe Vice Chair, would that information maybe impact or affect your consideration on this issue?
No, it wouldn't have a significant impact because, like I said previously, given that NMED appears to have the support of EPA, I think that they've met the requirements that have been set before them.
Thank you, Madam Vice Chair. Well, with that said, our board counsel did, as she was responding to some of the questions, reminded me that this is a public record and public information, and I just wanted to have my voice in there in terms of one thing, Wild Earth Guardians and the presentation that they provided to our board today, and as well as through all the submittals and preparation for this hearing, and also kind of echo and support what our member Duval mentioned about, working on the with the latest modeling and the data, and we hope to always improve. And as technology improves, as data improves, as the delivery and the data qualification and verification process improves and gets more efficient, I think we all strive to kind of work toward that. And some of that bureaucratically, maybe, sometimes our rules and regulations and processes that we have either at the federal level or state level may not always adequately keep up with that and to what we hope is the latest information and models. But I hope that we all work together to strive toward improvement of those processes. But I do want to thank Wild Earth Guardians for their presentation and information, and to what Member Garcia had mentioned earlier about trying to, take care of our air quality. I think that is also important. So I wanted just to put that on record, and then to Member Honker's recommendations. I know we can't put it in the final deliberations and decisions regarding this particular issue, but just to put on record that, we will continue to, encourage that of the New Mexico Environmental Department that we provide oversight and guidance for. So I hope that we can continue to work toward that. With that said, I don't know if anybody else has any other comment. I do also want to say, we are also as a board bounded by the existing rules and regulations and processes. So to what Member Vice Chair Trujillo Davis said and others on our board, we're trying to figure out how we all move collectively, and so as rules and regulations continue to be revised and updated here in the upcoming months and years, we'll continue to look at those and see the implications of those changes on our processes and our deliberations and the legal framework that is already established. So thank you all. With that said, I don't know if there's any other comments, and if not, I would entertain a motion from our members. Or if we need additional discussion on any aspects regarding what we heard today or any of the submitted information.
With some assistance, I'm happy to make the motion for approval of the SIP. Or we'll just stating that suffice.
Board counsel, would that suffice?
I think that's sufficient based on how it was framed by the petition.
I'll move approval of the SIP as submitted.
Second.
Great. I have a motion by Member Bitzer and a second by Member Cates. If there's no further discussion on that motion, I look to Ms. Jones for our roll call so we can get it on record, our votes.
Okay. Member Bitzer, how do you vote?
Aye, yes.
Okay. Member Cates?
Yes.
Member Duval?
Nay, no.
Member Garcia?
Yes.
Member Trujillo Davis?
Yes.
Member Honker?
Yes.
Chair Sweeney?
Yes.
Madam Chair, you have 6 votes for and 1 vote in the negative.
Thank you, Ms. Jones, for that roll call vote. Appreciate that. Board counsel, I think the next phase of this process is, now that we have a vote, how we move forward in terms of making sure we have all the documentation for this issue. I'm looking at the script here. Do we need to have our hearing officer have discussion about the next task to summarize everything?
Yes, Christina, I will go ahead and prepare a written final decision on behalf of the board for your signature. I do actually have a question for NMED Council, if I may, to that point. Mr. Knight, so this proceeding was postured as a rulemaking proceeding, and the final decision, as just voted on by the board, is to approve the SIP. As you know, in the board's rulemaking procedures, there's language to the effect of publishing this as a rule. What are your thoughts on that? That those are simply inapplicable, or how do you think that those apply, since this isn't a straightforward rule adoption proceeding?
Yes, Council, thank you for the question. And I do believe they are inapplicable. We did submit as our final exhibit, we submitted a statement of reasons and final order, which could certainly serve as a template for the board's final order. All we really require is just a written document signed by the chair, memorializing the board's action in approving our certification today. And I agree with you, though. Yeah, there is no rule to publish pursuant to the State Rules Act, and the document's already a public document. So I think all we need from the board is some form of final order. It doesn't have to be the one we submitted, but just some form that memorializes what was done here today.
Thank you for that, Mr. Knight. With that information, Board Council, what's the next step?
There's nothing further for the board to consider. After we adjourn, then I can put that together for your final review and signature, and that will be what will be circulated to the parties and to the public.
Okay, thank you so much for that clarification. I appreciate it. So I guess it looks like item 5 on our agenda, we've been able to address that. And thank you again for Hearing Officer Bitzer for your assistance in accomplishing that. Next agenda item is discussion about our next meeting on June 25th. So June 25th, do we have, I believe I recall putting that in my schedule as a pretty long meeting, starting at 8 or 9. Is that correct?
That's correct, Madam Chair. And the board actually has 2 rule hearings scheduled for that day. And as a reminder, Member Trujillo Davis will be serving as hearing officer for 21-07. And I believe Member Cates was appointed for the second rule hearing, which is 21-09.
Thank you for that, Board Council. So looks like we'll have another long meeting in June. So I appreciate both Madam Vice Chair Trujillo Davis and Member Cates for being the hearing officers on those 2 items next month. And I believe we'll be doing Zoom again. Is that correct?
Yes.
Okay. Great. All right. And then I guess the next item on our agenda is adjournment. Do we have a motion for adjourning today?
I move we adjourn.
All right, Member Honker, thank you. And second? Member Garcia, seconds. All right, just for formality, Ms. Jones, would you do a roll call on that vote?
Yes, to adjourn, Member Bitzer.
Yes.
And Member Cates.
Yes, we'll see everybody next.
Member Duval.
Aye.
Member Garcia.
Yes.
Member Trujillo Davis.
Yes.
Member Honker,
Yes.
and Chair Sweeney.
Yes.
Madam Chair, the motion passes.
Thank you, Ms. Jones, and thank you everybody for coming today and participating. And I know it's been a lot of work reading through all of the submittals and information, but thank you for all your work and your service to New Mexico. Appreciate it. Have a wonderful weekend. Safe, wonderful and safe weekend.
You well.
Yes, you too.
All
And thanks,
right.
Member Bitzer, for chairing the hearing today.
Thank you so much.